Session on Division 1. Good morning, everyone. As always, we have to read the commercial statement. As Chairman of Division 1 of the House Finance Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with House Rule 67 and the governor's emergency order number 12 pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a work session pertaining to division budget matters. Please note there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform, and the public has access to contemporaneously listen and, if necessary, participate in this meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice for this meeting complies with House rules and RSA 91-A. Anyone who has a problem accessing the meeting should email lba_fiscal@ledge.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. LBA staff are on the meeting and assisting us. Please note that all votes that are taken during this meeting shall be done by roll call, and we will, as always, start the meeting with a roll call attendance. If you're remote, you need to state your presence and whether anyone is in the room with you during the meeting, and that's required by the right to know law. We are in room 202. To my left is Vice Chairman Tracy Emmerich. To his left is Representative Peter Leishman. To my right is Representative Jerry Griffin. I believe Representative Taberge is in the car on his way. Good morning, Representative Hatch.
Good morning, Madam Chair. I'm at my home in Gorham in the basement, and my bride is amongst us somewhere here. Thank you.
We'll do our best to get you out of the basement this week for some time. Representative Walls.
Well, I'm at my home in Bow, and my daughter and my husband are elsewhere in the house, nowhere near me.
Thank you. This morning we have with us the governor's budget director, Matt Malou, and I think we have.
Should be DJ.
Is DJ Betancourt online?
Or
DJ
Commissioner Nicolopoulos.
Commissioner Nicolopoulos is online for sure. And I'm going to promote them to panelists. I don't think that worked. Try this again.
Looking for your techie so I can get my.
Room 205, Ryan is in there. I know we had a little technical difficulty ourselves, Ken.
Good morning, everybody.
Morning, Mr. Chairman.
Okay, Representative Weiler just came through. He's also having a little bit of technical difficulty this morning. What page are we on in House Bill 2? We are going to be discussing the family leave provision in House Bill 2, page 30. And section 69. I've asked Matt to go through this, and DJ, it's nice to see you remotely. I've been wanting to talk to you about the fact you're letting Ava grow like a weed.
Too fast, much too fast.
Much too fast. All right, DJ, we want to do this kind of like a bill hearing, and I think you can put on your former rep hat. So we want to start, and I told Matt this, go through every section at a time, tell us what it says. There may be questions as we go along, and if there are, I will let people ask their questions. So we're at the bottom of page 30, section 69. There's only a couple of lines there, but whoever wants to start going through that, please.
Sure, Madam Chairwoman, if we may just begin with a few opening remarks.
Sure.
On how important this section of HB2 is, and there's a lot of history here. And DJ will speak to this a bit more as well, but Governor Sununu first introduced this voluntary paid leave plan in his budget 2 years ago. We committed then to deliver this to the people of New Hampshire without an income tax. And we're here again 2 years later to follow through on that same commitment, voluntary paid leave using the state workforce to drive down market premiums for other private employers and to do it without an income tax in the granite state. This is an opportunity to be a workforce driver, to attract young families to New Hampshire, and ultimately provide these benefits, not just for the largest businesses that are already finding ways to accomplish this by self-insuring, but also delivering it to the small and mid-sized businesses throughout the state. We have a very dynamic proposal that leverages both the state and the private market. And we're confident that this is a productive path forward for the state. And from there, I'll turn it over to DJ, and then we're happy to go through the bill.
Okay, Matt, thank you very much. DJ, why don't we turn to the top of page 31, because basically it's just the title at the bottom of page 30. And line 4 begins the purpose and policy. Do you want to kind of address that section? So if you could do line 4 through 22 or through 21, we'll see if we have any questions.
Sure, Madam Chairman. What I can also do as well, if I may, is I prepared some remarks this morning for you that kind of just lays the overview of the plan, highlights some of its features, and then we can obviously, I'm going to have Matt lead the section by section, but we can answer questions and support him as well. So if I may, Madam Chairman, just very briefly, as you know, in my previous role in the governor's office, I was an advocate for approaching paid family medical leave and the approach that is before you today. However, in my new role over at the insurance department, I'm here this morning to be a resource to the committee and to highlight some of the more prominent provisions of this plan, and then obviously, as I said, to answer any questions that you may have. So the structure that is before you this morning is similar to many of the previous proposals the governor and the governor's office has put forward in the past, with the most prominent and fundamental feature being that this program will be administered by a private insurer who will serve as the state's vendor for the program. There has been at least 2 proposals prior to this, and some of the details have evolved over time. And so I'm going to try to break this conversation into 2 pieces. The first piece will be how it works, and then the second piece will be how individuals and businesses will access the product, and then what the coverage will entail. So before I take you through the plan, I would note that many of the features and adjustments to this plan came as the result of a request for information that the insurance department put forward in 2018, and it seeks to incorporate the feedback from the insurance industry on how best to approach these types of insurance products. The first feature to note is that access to this coverage is universal. For state employees, this will be a benefit provided to them by the state, and those approximately 10,000 employees will serve as the foundation of the risk pool for this product. For businesses will have the flexibility to opt into the coverage for their employees. For those businesses that choose to participate, they will retain the flexibility to determine how they want the premiums to be handled. That is to say, they can either choose to provide this as a fully paid benefit to their employees, they can choose to split the cost with their employees, or they can have the employee pay for the coverage entirely on their own. If the business does choose to participate, this plan creates a business enterprise tax credit that will be used to incentivize participation, which obviously has the intended desire to further drive down premiums. 50% of the premium that an employer pays for this coverage can be claimed as a credit against the BET.
So DJ,
Yes.
what section am I going to find that BET tax credit in HB2?
I'm at a little bit of a disadvantage, Representative. I have an older version of this. Matt, if you could help me.
Yes, that is on page 40, section 74, details the terms of the BET tax credit, and we'll come back to that.
We'll come back to that when
As
we
we
get
go
there.
through.
Thank you, Matt.
Yeah.
Thank you, DJ.
You betcha. So, so that's the tax credit piece. If a business chooses not to participate, or if the individual is an independent contractor or simply wants to access this product entirely on their own, they will have that access to individual coverage. Premiums for the individual opt-in group will be stabilized by a premium stabilization reserve fund. And anticipating the question, Matt, do you want to cite that section?
Yes, I will. 1 second and let me find that.
We're giving Matt a lot to do today.
That is on page 38. It is within the same section. It is line 15, which is 282-B:5.
Awesome. Thank you, Matt. So this model of a premium stabilization reserve fund is based on the state's Medicaid expansion program, where the portion of the insurance premium tax derived from plans offered under the Granted Advantage program are used to pay the non-federal share. So this mechanism will also help to limit the weekly premiums for individuals in this group to $5 or less per pay week. I just take this opportunity to highlight that $5 per pay week and where that number came from. So as I said in my previous role, I was heavily involved in this in the governor's office. And that $5 per pay period number came from advocates of paid family leave who had done these types of programs and put together these types of products in other parts of the country. And what they had told us was that $5 was kind of the red line by which, if you went above that, it would begin to serve as a disadvantage for people to seriously consider taking up that product. So with that number in mind, we've designed this to do everything possible to keep that premium below that threshold. So that covers a little bit on how to access the coverage. Now let's talk a little bit about what will be covered. So this plan provides 60% of wage replacement for 6 weeks. The maximum duration of wage replacement shall be 6 weeks per year with no minimum duration required.
And if you're, DJ, excuse me, if you're following along at home, guys, that's at the page at top of the page 33. Thank you, DJ.
Thank you, Madam Chairman. So the things that will be covered, let's turn to that. So the first is the birth of a child or the care of the newborn child within 1 year of birth, the placement with an employee of a child for adoption or foster care, and the care of the newly placed child within 1 year of placement, caring for the employee's spouse, child, or parent who has a serious health condition, any qualifying exigency arising out of the fact that the employee's spouse, child, or parent is a covered military member on covered active duty or caring for a covered service member with a serious injury or illness if the eligible employee is the service member's spouse, child, parent, or next of kin. And finally, a serious health condition of the employee that isn't related to their employment, and their employer does not offer short-term disability insurance. So a couple of things as it pertains to that last eligibility category. The first is obviously if the reason for the leave is related to their employment, that's going to be covered by their workman's compensation. And then the second piece is around that first person coverage. And that was the subject of some discussion last year. A large portion of costs associated with paid family medical leave are tied to the disability portion of the coverage. And the thought last year was that since most New Hampshire employers have short-term disability benefits, the goal was to avoid cost that was deemed to be duplicative coverage. Now, that being said, this was the source of some passionate disagreement. So to address that concern, this plan includes first-person coverage if their employer does not offer that short-term disability insurance.
Matt, again, can you tell us the line in the page for the short-term disability insurance?
Yep. Matt, that's the provision in the business and individual coverage, which is a little bit later. Looks like section 6.
So this is page 37, line 24, 282B:3.
Okay, that's good enough. We'll get to that later. I'm just trying to make sure we get all these references down to time
Sure.
together. Thank you,
Sure.
guys. Thank both of you. Please, DJ, continue.
Of course. Thank you, Madam Chairman. So to conclude this discussion, I'm going to briefly touch on some of the additional features. So the first is job protections. So individuals who work for an employer with 20 or more employees will have job protection. Now, here again, there has been a bit of discussion about whether that should be 50 employees, which would mirror the Federal Family Medical Leave Act, or whether it should be some number lower than that. The governor ultimately decided that the number should be 20. But that's obviously something that you will have to consider whether that you feel that that's the appropriate number. Obviously, more protection means the greater likelihood that people will be motivated to access the coverage. The more people in the pool, the better the premiums. Second is through the RFI process, insurance carriers and legislators had raised the issue that the individual opt-in group may experience adverse selection. This new plan revises and tries to address those concerns in several ways. The first is that there will be an open enrollment period for individuals in the opt-in group, and that will be limited to once a year and will last approximately 2 months. The second is that the rating will not be grouped with the state employees or the other employers of the state, and it will be based on the claims experience of that particular group. And finally, there will be a 7-month vestment period to allow the program to become capitalized. Now, I understand that some of these features may not be the most popular of this plan, but if you want to guard against adverse selection and again, ensure that you are driving down those premium costs to below $5 per pay period, then from an insurance standpoint, this is how you'd approach it.
Okay, DJ, I do have a question if I could. Representative
Sure.
Leishman,
Thanks, Madam Chair.
is your mic on? Yes,
It
it is.
is.
Good for you.
I'm learning after about a couple.
Okay,
weeks.
Mary Beth, you're training us.
So if we could back up, you mentioned the protections for folks that are, I guess, companies that have 20 or more individuals. What about the companies that employ less than 20 individuals? What kind of protections, if any, are there for them?
So there are no current protections in terms of that guarantee that the individual will not lose their job if they need to step away from their job for any of the qualifying conditions.
And what I would just add to that, and this is at the bottom of page 37, line 36, Roman 3. Employees of those companies that don't qualify for the job protection elements have the opportunity to join the individual purchasing pool to receive those same benefits.
So basically, Matt, I'm not sure I understand, but Representative Leishman asked what happens if you don't work for somebody who has 20 employees? And your answer is there is an individual protection component that individuals in smaller businesses could join if they chose to do so. Is that correct?
That's correct. And that section begins on page 36. And I apologize that we're jumping around.
That's all right.
will go-
I'm making little notes. I suppose everybody else is. Representative Leishman, do you have a follow-up?
Yeah, thanks, Madam Chair. So if an employee is disciplined or faces some sort of action, is fired, what state agency would he go to file a grievance against the employer for such an action by an employer against that employee?
So just so I understand the scenario, this is an employee that participated in this benefit and was then fired because they took
Right.
part in this benefit. DJ, is that something that you could speak to? This might ultimately be decided through rules. I don't know that there's a specific section of the legislation that addresses that.
Thanks, Matt. So Representative Leishman, are you referring to an individual who, if you were to set that bar at 20 or more employees and they were terminated as a result of that, where they would go to have that addressed?
Yeah, or if they learn that they thought their employer was holding money back or taking the 5% a week for that benefit and then learn that the employer was not putting that money aside, where would they go to file such a grievance?
I think it's $5 a week, not
Right.
5%.
Or $5 a week, right?
Well, Representative Leachman, I think it could go a variety of places. Commissioner of Administrative Services will administer this program. But if an employer was charging a premium and not providing the benefit, our Consumer Protection Division here would have something to say about that as well.
Okay, but that's not in the bill as of yet. That's something you develop later as far as rules. Is that your understanding, or?
Or is that in rules that you have for your agency overall?
Well, there isn't a rule specific to this potential fraud that would be there, but it is both. I think in theory, it's a violation of our statute for charging insurance premium that you're not provided. The Commissioner of Administrative Services is going to administer this section, and so I assume there would be appropriate to have rules there as well.
Thanks, Madam Chair.
Okay, please continue.
Madam Chair, I'm sorry. If I may.
I'm sorry, Representative Hatch, I did not see your hand up. My apologies. Please
That's
ask your
fine.
question.
When I chaired JELCR, I missed a lot of hands myself. And thank you for that. My concern is exactly that, rules. I often hear that could be addressed in rules. Having served on JELCR for a number of terms, having chaired that committee, I'm not sure that's what we need to hear. Rules, that would be mandating that JELCR legislates, and that is a big no-no, so to speak. And if something's not laid out in a bill, and it's not clear that that's the legislative intent for that activity to happen, under 541A, that's really not something that goes forward in rules. There has to be an indicator somewhere that that's desired. So to expect, and I'm sorry, Madam Chair, with the lack of the better terms, things that are missed in the legislation, and this often does happen, and expecting rules to address that, not a good plan. And you can't guarantee that would be addressed in rules. So my thought is it needs to, I guess there needs to be a further explanation of Representative Leachman's question, other than it will be addressed in rules. Thank you, Madam Chair.
And Representative Hatch, what I would say to that is if a company is defrauding its employees, the state already has existing mechanisms to address that outside of any particular program. And I think to Commissioner Nikolopoulos's point, those existing pathways would continue to exist.
So if I may, Madam Chair.
Follow up.
Follow up, thank you. Well, that would be considered fraud, but with that, you have to talk about intent and all sorts of things. There's a lot of things that it's clear that there's protection there, and I'm not a lawyer, but we have lawyers on the committee. I'm not sure that's something that would be captured under fraud. Thank you, Madam Chair.
You know what I think I could offer is I could have my team put in a reference to our insurance statute regarding charging premiums and not providing a benefit to make it clear. I'll put that together to make it clear that we would have authority to assess administrative penalty and to administer those claims.
Could you do that today?
Yes.
Thank you. If you could get that to me and to LBA, Nancy Labinas and Michael Hoffman today electronically, or get that to Matt, and Matt knows how to get it to us, so we can do that. Representative Walsh, you have your hand up for a question. Do you have a question?
I do. Thank you very much, Madam Chair. So I want to go back a step and revisit. So if we've got somebody, say they have 20 or more employees, say somewhere between 20 and 50, and they is some sort of retaliation or some sort of problem that arises because of what the employer is doing because somebody has chosen to exercise their rights under this. You suggested the Department of Administrative Services is where they go. There is no enforcement division. There's nothing within the Department of Administrative Services that I know of that would allow them to have some sort of mechanism for protecting the workers. And
Commissioner Nikopoulos is from the Insurance Department, and I believe he was referring to his department, not DAS.
And actually, I think
Rep-
the job protection would be equivalent to FMLI protection that would be existing, just the same as any other a violation of family medical leave protection for those employees over 50 that currently exist. So if we're adding here a state provision that says for employers over 20, if they took adverse action because someone took the benefit of this coverage, that it would be a state-based claim for a violation of the family medical leave protection. That would not be administrative services. That would be a.
Thank you, Commissioner.
no,
And
wait.
Representative Walls, what I might just add to that, the reference to DAS is that DAS is the administrator of this program as it pertains to the state. So the DAS would be charged with soliciting proposals for this and then administering the program. I think that's where the reference to administrative services came from.
They do administer other state employee benefits.
Yes.
Follow up, Madam Chair, I just wanted to be clear. I want to check with Commissioner Nicolopoulos. And so what you're suggesting is if there's a problem, that there is a mechanism to enforce FMLA within the insurance department?
Representative Walls, no, that would be it'd be a I believe an EEOC claim initially, and then it would be a lawsuit for a violation, just like any employer would access.
But if it's a state plan and you're talking 20 to 50.
You have another follow-up?
I do. Thank you. Does the EEOC have jurisdiction on a state plan with 20 to 50 employees, or where would that person turn?
Well, that's a state law protection. So they would be EEOC is the first step, and then ultimately the courts, if they don't take it up, would be enforcing our state law. The protection, that's where they would get that authority.
Thank you, Commissioner. Representative Hatch, do you have another question?
It's not.
I do. I apologize, Madam Chair, if I may. If somebody's disciplined or dismissed for participating in this program, I'm not sure I understand that Representative Leachman's answer was questioned to retaliate against. Now, the scenario is the people are paid the benefit, but the employer dismisses because they are taking the benefit and wants to either replace them or whatever, or feels that the employee is being unjust in asking for the benefit. That's the protection that I'm wondering about. And
What is your question, Representative Hatch?
Where is the protection for the person? It's not fraud if the person's paid the family leave.
Okay, why don't we let them go through the sections? We're still kind of going through definitions. I think that's a good question. Let's go through the sections. We don't know that yet. We don't know what's in the
Yes.
plan at all.
Thank you, Madam Chair, and I apologize for jumping in. Thank you.
And I think some of the confusion might be that protection's being used in two different senses throughout this conversation. But let's go through starting the top of page 31. You
Okay,
see-
we're going to go through the plan section by section. And then when we get done, we'll know whether we answered any of those questions or not once we really understand what's in here. Thank you. Matt, are you doing that now?
Yeah, so I will take the lead on this and punt to DJ where necessary. But lines 4 through 22, the policy and purpose, that's what I tried to articulate to begin this morning's testimony. It's fairly straightforward what we're trying to accomplish here. Lines 22 through 12 onto the next page are the definitions. You see the instances of when leave from work is covered. DJ previously spoke to those. You also see definitions for serious health condition as covered by the Federal Family Medical Leave Act. I guess any questions on those first two sections?
Specific questions on these 2 pages. Representative Walls.
Oh, Madam Chair, I just hadn't taken my hand out. I'm still trying to
Okay.
figure out how the EEOC is going to enforce state law, because I don't think.
Okay, we're going to continue going through the plan.
On
Turn the
page,
page to 33, please.
or I would continue in the bottom half of page 32, if I might.
Bottom of page 32, I rushed, sorry.
Line 13, contracting administrative authority. This directs the Commissioner of Administrative Services to solicit information for an RFP. You see that section continues relative to the coverage that we've previously defined for those different categories.
And Matt, I assume this language for the contracting administrative authority is consistent with the other language we've given the DAS commissioner for the other state benefits that he does for us.
Yes, this would be something that they've done in other instances and would be familiar. On the top of page 33, and DJ already covered this as well, it is a 60% of the average weekly wage with a maximum duration of 6 weeks per year. Subparagraph C caps the amount of the benefit at the Social Security taxable wage maximum, which I believe is $133,000 or thereabout. So there is an upper bound to what this benefit would provide. Lines 6 through 16 discuss the initial phase in, if you will, for employees, right? So a 10-year requirement in terms of months of work before they're eligible. And then similarly, a waiting period, which shall not be a required element of the structure. Now on line 17 and through the next page, this talks about the opportunity for the public employees to leverage that for private employees, right? So the theory of change here is that we will use the state workforce, that 10,000 person pool, to help buy down premiums in the private market, that we have a critical mass that will make this coverage affordable, not only for the state, but also for those private employers and their employees that want to take advantage of this benefit. You see the terms on line 32, 33, and 34 that discuss a 7-month waiting period, a 1-week elimination period, and a 60-day annual open enrollment period, and that premium shall not exceed $5 per subscriber per week. On to page 34. You have the conditions for private employers to establish a voluntary coverage, that non-state employers may choose to provide FMLI at no cost to their employees or on a contributory or partially contributory basis. Again, this is what DJ had discussed, that the private sector employers have flexibility on how they would want to extend this benefit to their employees. From there, you see lines 11 through 21 discuss the procurement process and how the state would go about selecting a private vendor to administer this for state employees. 22 through 32 discuss the discretion of the Commissioner of Administrative Services to modify the initial benefit structure is within his authority under this. And then on line 32, you see that the FMLI Advisory Board is established, administratively attached to DAS, is a 9-member board that becomes an oversight commission to help resolve problems of the procurement, eligibility, benefit design, and program administration. On to page 35 now, lines 11 through 18 discuss outreach initiatives to continue evangelizing the benefits of this program and encouraging more private employers to take advantage. There's a reporting requirement and also working in coordination with the Department of Employment Security shall develop and implement that outreach program that I was just referring to.
What do you see as the purpose for the outreach, Matt?
Ultimately, the larger this pool becomes, both in the private and public sector, the lower the premiums will become, which is a benefit not only to the state, because the state is committing to provide this coverage, but also to employees and their employers in the private market. DJ, I don't know if there's anything more on that point that you'd like to add.
I think you've summarized it perfectly, Matt. It's the basics of Risk Pool 101. It's the same principles that the state uses in promoting the individual market. And you've summarized it very well. The more people you have in that risk pool, the lower your premiums will be.
While we have the mic, I just wanted to clarify the answer regarding where they would file a claim regarding a violation of the 20 employee limit. I verified with a lawyer who does this work just a second ago, and provided that we don't change the definition of discrimination in 354A, an employee would not be required to go to EEOC first. They would be eligible to immediately file a Superior Court lawsuit for a violation of this protection. And it would be a state law based claim, and it would be a fast access to the Superior Court.
Thank you, Commissioner. I think Representative Leishman has a question on some of the pages we're going over. Representative Leishman.
Yes, I do. Thanks, Madam Chair. But just a comment for the commissioner. I guess I'm concerned that someone would be forced to go to a Superior Court because, as you being a lawyer yourself know the expense and sometimes the delay that would cause, and somebody in a situation that was looking for this type of coverage to have to file an action with Superior Court would seem somewhat onerous, at least to me. But I do have a question, Matt, and staying as the chair is urged us to by page. This advisory board, would anybody be compensated? Those 9 members you're proposing, would there be compensation for them?
I believe the only compensation for that board would be legislative mileage for the members of the legislature that participate. What I would just go back to on your concerns about how someone would bring a claim to state court, I would just like to stress that the scenario in which the question is going down assumes that an employer who is opting to provide a voluntary benefit to their employees, right? Because we're not mandating this coverage. This is a voluntary opt-in basis. Why would an employer opt in to this program only then to renege on that new benefit they've established for their employees? I understand that that might happen, but I think your concerns would be much more warranted if we were mandating this on small businesses, and that just simply isn't the approach we're taking here.
If I could respond, Madam Chair, I think you're probably missing my point that the employer is collecting the $5 a week, and for whatever reason, he keeps that money or it doesn't get credited appropriate. That's my concern. The protection, whether it's voluntary or mandatory, doesn't have any bearing. It's to make sure that that payment is credited appropriately and the employer is not using the money for some other purpose, even though it'd be a small amount. But if they had 20 employees and they were all participating in time, if the employer wasn't making sure those payments were forthcoming, then obviously the employee could be hurt.
And
that's where I'm going.
And I
guess the
understand that
protection.
concern, but again, this would be something that they would have to opt into, and those existing avenues would exist for something in that scenario. I don't think that's any more onerous than if an employer was withholding wages or not meeting other existing guidelines under or laws under state or federal law.
Thanks, Madam Chair.
Okay.
And
Yeah,
Representative
please
Leishman,
continue if on the pages.
From there, we're on page 35. You see the rulemaking authority in line 26. On line 28 is the appropriation and funding transfer. This essentially is an accounting mechanism for the Administrative Services Department to fund those costs, which are then further delineated on line 31. Sets a request for proposals to be issued no later than September 30th, 2021. We believe this gives DAS sufficient time once the budget is enacted to proceed and issue a timely RFP with the intent that this program is up and running for state employees by July 1st of 2022. That, of course, is the start of the next fiscal year, right? The second half of the biennium. There is surely an opportunity to accelerate that timeline depending on how the RFP process goes. But the intent is that this benefit is in place for state employees within the biennium.
So Madam Chair, as long as we're talking about the funds and appropriations and transfers, a number of the bills, Matt, we've seen on this have had a fixed figure, I think, of anywhere between 2.6 and more $1 million of general funds to get started. What are you proposing as far as you mentioned, general fund transfer? How much are you looking to transfer to get this up and running, general funds?
So what I would say ultimately is that this program is going to be dictated based on the rate that the state solicits during that RFP process. That rate, depending on private market adoption, will continue to be driven down. But to walk through an absolute worst case scenario where we're at that $5 threshold cap, if you look at the 10,000 state employees, give or take, times 52 weeks a year, it's at most a $2 million hit. And that assumes this program does not become as successful and widely adopted in the private market. But we think that given a healthy and robust adoption, this becomes a de minimis benefit in terms of costs to the state. And you'll notice that the funds from the insurance premium tax, which we'll cover on page 36, are specifically allocated for that purpose. So again, we don't see this as a cost driver for the state by any means, because even the way we've structured this program is that the more successful it gets and as time goes on, the cost to the state will continue to decrease.
So you're proposing, and we are just getting to line 35, section 70 and flipping the page. That is, you're telling us that is non-general funds.
Yes, and that is the new language there in subparagraph C. Premiums written and authorized by the insurance companies are deposited into this premium stabilization fund, which we'll cover here in the purchasing pool for 282B.
We don't usually transfer funds to an agency to write an RFP. So if I can go back to, Representative Leishman and I were thinking the same thing, but he was a few lines ahead of me. I'm going to go back to lines 31, 33. We don't usually do that. I don't see that we would need that. DAS writes RFPs for our medical coverage, for our retiree health, for a whole variety of things, cybersecurity, all kinds of insurance, any insurance the state has. They have a whole unit that does this. So I'm not sure we need those lines because we do fund them to do that.
I would just point out, I think these are different sections of the law. So one is detailing the program startup, and that's the lines 31 to 34 that you were just referencing.
Yeah, but it says that you have a proposal. Did I misread that? I must have been
I think you're looking at lines 28 to
28
30.
to 30. You're correct. I named the wrong lines. Thank you, Matt.
And then that would just be those startup costs for implementation, right?
But that's why I'm saying DAS is funded to do those things now.
I don't believe that's tied to the RFP issuance, but I would defer to DJ if he has a more specific answer, or we're happy to report back in the alternative.
DJ, lines 28 to 30, what's the cost?
Yeah, as Matt said, let me dig into that further and let me make sure I'm getting you the correct number.
Okay, can you get that to me this afternoon?
I can.
We're only meeting till noon, but then we have to be all day at the public hearing, but I will have a chance to check my emails as we go along. So I'd appreciate that. Thank you, sir.
And we'll bring all of that consolidated together into one.
Okay, Matt, please continue. I'm sorry I made you go back a page, but
No worries. On page 36, you see the new chapter, chapter 282-B, the purchasing pool for family and medical leave insurance. This is a new section of the law. So again, you'll see the existing purpose, the same definitions that we've already reviewed. Those are restated here in an identical manner. That brings us to page 37. employer and employee rights and responsibilities. And I think this is where most of our conversation this morning is already headed to. And I'll just spend a little bit of time on this section. So Roman 1, individuals who are employed by private employers that do not either family medical leave insurance under this program or a similar benefit with at least equivalent coverage have the opportunity to purchase that coverage through the individual pool, right? So this creates a mechanism that whether or not your employer opts in, whether they are based on size or just any other reason, those employees are not caught out in the cold. They have an opportunity to buy in through an individual market. That brings us to pay Roman.
Line 28, 29, and 30. The end of line 28. The individual pool shall operate by payroll deduction. You're requiring a small business who opts not to join the program, but has 2 or 3 employees who decide to join and may or may not join the same program for family leave, because there's more than, I think I know of 3 family leave programs already operating in the state. We've talked about this before. We've been talking about family leave for years. You're requiring the little business to make payroll deductions. I mean, the little business doesn't make payroll deductions for my car insurance. Why wouldn't I pay that on my own?
And I can help with that if you'd like. So the thought process, Representative Ober, at the time was that because these businesses have the infrastructure and the systems to collect a variety of taxes and fees on behalf of their employees, that this could simply be slid into that same infrastructure. Now, that being said, there are a number of different ways that you could approach this potentially. If you wanted to put the onus on the individual in a business of a certain size or less to pay the premium directly to the insurer, you could certainly do that. But this has been a topic of conversation in the past, and for simplicity, where the conversation had landed, at least as of last year, was that because, as I said, there is some familiarity on behalf of the business to collect and remit things both to the state and federal government, that this would not be an overly burdensome ask.
Well, small businesses disagree with you, DJ.
I suspect there is probably some varying opinion. Yes, ma'am.
Yeah, a great deal of it. I'm just bringing that to your attention. Representative Hatch, I see your hand up. I think you're muted. Oh, you took your hand down. Okay.
No, I took my hand down, BJ. I was muted. Thank you. I'll understand this eventually. Thank you,
Okay.
Madam Chair.
Please,
Now-
Representative Leishman.
No, Madam Chair, I have my question.
Oh, you do have a question.
okay.
I'm sorry, Representative
Thank you.
Hatch.
No, I apologize. The onus is on me. Just back to this employers having the deduction. I never had more than 24 employees. This is not, like you said, DJ, this is not, wouldn't be overly cumbersome for me, but I do have concerns. And I need to understand this better, and maybe there's a quick answer. I see that the most a individual can be charged is $5. So if I have 24 employees, their premium is $5 per employee. I deduct that and I have my own insurance, but I don't see anywhere in this bill that doesn't allow insurance companies to charge more than $5 per individuals. And who's liable for that additional amount? As an employer, I can only deduct $5 from them for this program. As a state, the same thing, but nothing here indicates if the cost per individual is more than $5 per week, and who pays the difference? The employee can't. Would I have to as an employer?
Matt,
So-
are you getting to that? I understand his question.
Yes. And
And I apologize, Madam Chair, if that wasn't an appropriate question.
No, that's an appropriate question. Matt's looking through papers, so I think he's going to answer, not DJ.
so this is on, and DJ, please chime in as well. This is on page 33, line 35.
Page 33, line 35, in response to Representative Hatch's question.
which specifically deals with the individual pool, which is related to what we're talking about here. Premiums for individual pool coverage shall not exceed $5 per subscriber per week. So it's not a matter of who makes up the difference. We set a statutory cap on what that premium could be. And again, we see that only as a worst case scenario where, because we're leveraging the state workforce to contract with a vendor to provide that benefit for 10,000 state employees and then allow the private market to supplement that, we're going to continue to buy down those premiums at more and more competitive rates.
So Matt, let me tell you about a mistake I made when I drafted the drug court legislation years ago.
I don't believe there are any mistakes, Representative Ober.
Yeah, there was an oversight, if you will. And Representative Leishman was with me when we did that. We had trouble getting that legislation passed. We did get the legislation passed, but we didn't give any thought to what would happen 6 years later, 7 years later, 8 years later, when the cost of living has gone up and the amount we authorized really had no adjustment factor for inflation. You have the same situation here. $5 per week today will not be the same as $5 per week in 8 years, 9 years. How do we adjust that? And that's a concern I have that you're going to get back to me on, because I don't expect you to have that answer now, but you're going to give it some thought process.
I'm happy to provide additional thought, but I
Okay.
would also say there are two schools of thought about legislation. One is that it should take an act of the general court to raise any dollar threshold, period. Others will index something to inflation or half of inflation. This bill would, as written, would require the general court to take an affirmative vote to change that threshold. But I believe we would be amenable to scaling it with inflation, but that is I would say a policy determination for the general court on how much authority they would like to have on that cap.
Okay, so Representative Hatch's question was, which I don't think we've asked, what happens if it's more? Does the employer have to eat the difference? Was that did I restate your question accurately?
Very well. Thank you, Madam Chair. And not just the employer, as well as the state.
I think I might be able to answer this, and I think Representative Hatch is right, that the cap in the pool is to ensure that the individual premiums paid by an individual employee who decides to opt in alone is capped at $5. This bill in front of us does not cap either the state's portion or employers who opt in on their own to that same $5 cap.
So Commissioner, you're pointing out the line which we haven't really looked at, which is line 27 above that, which is the start of the paragraph that say individuals who work for employers who choose not to offer FMLA. So you're saying this applies to just that small group.
Yeah, right. And so it is possible, though, I think a lot of work has gone into to make sure that these estimates are right. It is possible that the state portion could be $5.25, and and when you factor in the stabilization money to ensure that individuals can get in, this bill does not yet or does not include a cap on what those kind of free market charges will be. There's a benefit design here that will allow companies to competitively bid on this product. The number could come in, the situation could be after we put this out to bid that the $5 cap is immaterial because all the numbers are under that.
Okay, but if we can focus on Representative Hatch's question. His question is, he's a small business owner running a business with 24 people. What happens if it goes up? Does he have to eat it? Your answer is, if he has chosen to join as a company, this section does not apply to him per se, because it only applies to companies where the business has chosen not to join as a company. Is that correct?
I'd like to separate the two potential possibilities that were kind of interwoven there.
Okay, but I'd like a yes or no answer. Is that a yes or no answer to Representative Hatch's question?
Thank you, Madam.
And he's nodding his head yes as well.
I'm going to give you 2 yes and no's to the 2 scenarios that we talked about. One, if Representative Hatch's company opted to provide this coverage to all its employees, and it was we'll just say $6 a week. He and his employees, as a benefit design, he could decide whether the company's paying for that or he's sharing it with the employees. And in that case, that would be a business decision that he makes. He could say, we're going to opt in and allow all the employees to join, and the benefit costs $6 and the company's not paying for it. And employees could opt to be in or not.
So
If-
Bill, you could pay all the money, you could pay none of the money, and the employees could pay the $6. So
And then-
there's your answer to your question as a company.
And then the second answer is if Representative Hatch opted not to participate and 2 of his employees opted to join through the individual market, those employees would be guaranteed a premium under $5. $5 would be the cap. And even if that coverage costs $6, because of the risk pool created under this bill, the risk pool would pay the difference.
But it does not go back to Representative Hatch's company as a small company.
100%.
Okay, Representative Hatch, I think we finally answered your question. Representative Walls.
Thank you, Madam Chair. So I have a question here. Let's say that we're collecting.
What page and what line are you on, please?
It's a more broad question. Just listen to my question. You'll understand, please. And that is, say that we're collecting $5 per employee. And it turns out that people are really taking advantage of this. And the cost to the state is closer to $6 or $7 per employee.
That is not what the bill says, Representative Walls. That's what we've just been going through. This line for $5 per week, page 33, line 27 through line 35 is for individuals who work for employers who choose not to offer FMLI. It is capped at $5. There is a line in here that we've looked at on another page that says employers may pay all, may pay none, or may prorate with their employees. So we're
Madam Chair-
not saying that a company that joins is capped at $5. Matt, is that correct?
Yes, that is correct as written.
Madam Chair, you misunderstand where I'm trying to go with my question. Where I'm trying to go with my question, let's just for the moment confine it to state employees. The state, I mean, it obviously the question's applicable also, but for the moment, we're going to say just for the state employees. Let's say the state employees start seriously taking advantage of this. We know 60% of our state employees are of retirement age. They are at the age you start having medical issues. So they start really taking advantage of this, and it ends up costing more than the premium. And it ends up costing more than the pool. Where does the money come from? Where does the state find the money to do this? Because it's going to cost more than we are collecting. And that's my question is, what is the burden on the state, not what is the burden on the employer?
That is a question. That is why we're using a private insurance company. They will do the risk. The state is not running its own insurance agency. It's no different from my insurance, which comes from a private company. Yours may come from Anthem. Yours may come from somebody. They have given us a cost for the year based on what they see their risk pool being. Is that not correct, Commissioner?
It is correct, but Representative Wall's question is a fair one, that it is possible that we go out to bid and the best bid is $5.25, $6. I think because the design here is such that state employees already have some short-term coverage. And so the part of this bill that's different for the state employees and for the private employers or for the individuals is that the first person coverage is already covered by another state benefit. That's covered by the state contract already. And so that is going to allow the carriers that are bidding on this to offset the cost. You know, the state's portion of it is actually going to be cheaper to deliver than the group portion or the individual portion. And so,
And just to build on that, Representative Walls, if you put that cap of $5 per pay week into a contract for state employees, what are the vendors going to do? The vendors are going to come in at the cap, more than likely, because they're going to guard themselves against upward pressure on premiums. But as the commissioners described, because state employee benefits are far more robust than the average in the private sector, that is going to guard from that sky high utilization that you posited in your scenario.
So follow up, Madam Chair, please.
Yes, follow up.
Thank you. So let's move then to the private sector that chooses to participate, those people with 20 to 50 employees. The same issue applies to them, that, they're going to be capped. Am I correct that they are also capped at the $5? Or no, they may need to charge more is what I'm seeing you say.
No, only where individuals join because their company did not join. Only those people have the cap.
And so if those people join and it costs more than the $5 and we exhaust the pool, where does the money come from?
Well, Representative Walls, what I would say is there is a stabilization account that is set up, and we haven't quite got there yet in the bill.
Okay, Matt, so why don't you continue if you think we're going to get to an answer that will answer that question.
Certainly.
Where are we?
On page 37 still, Roman 3 discusses employers with fewer than 20 that wish to provide coverage have the opportunity to purchase that by making remittances to the fund. Essentially allows smaller companies that want to provide this coverage an avenue to do so to benefit their employees. That fund is established on line 4 of page 38, which is the FMLI Premium Fund established. We make remittances. The Department of Administrative Services is instructed to develop student enrollment procedures with the participating carriers. And it goes through to some of those details there. On line 15, the Premium Stabilization Trust Fund is established. This is the fund that I was just referring to, Representative Walls, that will help stabilize the individual pool, which is held separately. And you see that, again, is derived from premium taxes imposed on premiums written and authorized by duly authorized insurance companies for FMLI insurance. Online, yes.
Madam Chair?
Yes,
So nobody has still answered my questions yet.
he's just getting to it. Let him go line by line through this fund, please.
No.
Thank you, Madam Chair. So on page 30,
Yeah, just go line by line through that. You said this would answer her question. You only got to the header.
so on page 38, Roman 2, which is line 25, says that the monies in this fund shall constitute a premium stabilization reserve and shall be used exclusively for the purpose of assuring that the premium charged to participants in the individual pool remain stable from year to year and do not exceed $5 per subscriber per week.
Do you
So-
believe that is what answers her question?
I believe that is what I'm trying to answer her question with, to say that in the event that the premiums are actually above $5, it's not a matter of who eats the cost. We've specifically developed a mechanism to resolve that issue that's based on premiums charged for this type of coverage that will stabilize that over a period of years. This is something that DJ referred to as similar to how we deal with Medicaid expansion, right? To hold rates more or less constant over time, and not have these wild fluctuations based on who chose to take advantage of benefits, or if you see swings in birth patterns or things like that. This is designed to smooth that out.
Follow up, Representative Walls.
Thank you. And what if the cost exceeds the fund? That's my question.
At
Has
that,
the cost exceeded the fund in the Medicaid expansion that we set up to do this?
I would have to defer to DJ or maybe the commissioner. could
Okay,
speak
can
to
somebody
that,
from
but
the insurance agency answer that question because Representative Walls has a question.
I don't know the answer to that, to the fund question. But the rates that will be assessed on the state and on the voluntary group participants will be set sufficient to offset the individual participants who join and the $5 cap. Now, like any insurance, the beauty of this product is we're asking a company who's in the business of using actuaries to determine what appropriate rates are to create this product for us and to bid it, understanding the framework that we're establishing in this, or that are established in this bill. If a company bids for this and has the product, they are required to offer it at $5 for the individual and for the members who participate. And if in a given year they have good performance or bad performance, that's going to impact the following year's rates. But that's the business of insurance, and the stabilization fund should allow for some flexibility in making sure that the swings are less. But I think compared to a option where FMLI insurance is provided by the state and all of the downside was going to be on the state, which we've seen in previous years, this product allows a business, an insurance company, to do that for us.
Okay, Representative Walls, I don't know if that answered your question or not. Do you have a follow-up?
I do, please. So let me go back to the state employees. What if the cost on the state employees, even with your short-term disability insurance, exceeds what we're bringing in premiums? Where does that money come from?
So we're using an RFP process to establish a rate. And at that point, that would be dictated by the terms of the winning bidder's contract with the state, right? They are agreeing to provide a service at a certain cost. If their actuaries don't accurately compute the cost, I believe that's something that would, I mean, the risk is transferred at that point to the bidder, right? That you are responding to an RFP to administer a certain program for a certain cost. And again, I don't know that this is something that we're trying to get into. And I guess the other thing is that this provision isn't all that different. This particular provision isn't all that different than Senate Bill 1, which was vetoed 2 years ago because it was an income tax. But I don't remember these same considerations being raised specifically on SB1, which had a mechanism more or less identical to this.
Well, I was not on that for SB1, but follow.
Okay,
and
let's
that-
continue. We don't really have time to bicker a point. Do you have a specific question?
I do.
Representative
So
Leishman.
What I'm trying to do is if the plan say that the bid comes in, say we're charging for state employees $5 per person. the
We are
plan
not.
says it's
I
six-
keep telling you that. The
Say-
plan for $5 a person is very clearly delineated on that page for individuals whose employer does not opt to join the plan. The state employees, the state as an employer is opting. They have then, per the lines we have read, the option to charge the full premium to the employee who may opt out, to pay all the premium to the employee who may opt out, or who to charge them a partial premium. In addition, per the lines we've read, if you offer short-term disability, which the state does, short-term disability takes over before this does. So we're not charging the state employees a $5 cap. That is not what the bill says. Representative Leishman, you have a question.
Thanks, Madam Chair. Just like to say, I do agree with Matt on one thing. If an insurance company does sign a contract with the state, they'll be obligated to meet the terms of that contract. So which leads me to my question, Madam Chair. When Mr. Betancourt appeared before us to present the governor's plan about 2 years ago, you said that you had reached out with a number of request for information to determine if there was interest by a number of different insurance carriers to the $5. And I don't think we ever heard back whether we got favorable comments back, because obviously an RFP was never put out, but request for information. How did that turn out? Did you have a lot of interest? Were they supportive of this $5 proposed premium?
Thank you, Representative Leishman. You are correct that we have relied heavily on a lot of the information that we got back from that RFI. In terms of interest overall, there was a great deal of interest for this type of approach. Don't quote me on this, but I want to say that we got responses back from approximately 8 to 10 insurers who expressed interest. They provided the state with some advice and some feedback. A lot of that advice and feedback centered around adverse selection, which gave rise to the provisions that I highlighted earlier that address that problem. The question as it pertained to the $5 per pay period cap or threshold was not raised with the insurers. As I mentioned before, where that came from, the genesis, if you will, of that came from advocates of paid family leave who had done research and who had done work in other states and had identified that as the threshold by which it would not become overly burdensome financially for people to access that coverage.
Thank you. Thanks, Madam Chair.
Matt, please continue.
I believe we are on page 38, line 25, Roman 2. I believe that's what we had just covered.
Yes.
Again, you see similar language on the reporting and outreach that we've already detailed. And again, the theory there is that more participants will drive down premiums for everyone. The other thing that I would say, especially for whoever does win that contract with the state through this RFP, they have a first mover advantage that unsuccessful bidders would not have, right? Because now they've already established a large pool, and that will help that provider provide lower rates in the private market. So there are benefits, to DJ's point, as to ultimately, being the sole provider of the state under that RFP. On page 39 now, you see the rulemaking authority, again, delineated here, the appropriation and funding transfer. And again, this is for the individual pool, again, delineated here. The implementation. This section here, there is one technical correction just to align this January 1st, 2022 date with the July 1st, 2022 date that I already specifically referred to, that start of the fiscal year. We would want those dates to be aligned, and I apologize.
So
that
what should that?
July
date be?
1,
July 1, 2022.
correct. And I'm happy to bring that as an amendment if needed.
I think I can get it, Matt.
Section 72 of the bill, that's page 39, line 18, discusses discrimination in the workplace. And this is specifically what we were talking about with the job protection provisions. So if the company opts in and is larger than 20, there are job restoration provisions at the end of that period of leave. And this here is consistent with the provisions of the federal FMLA or Federal Family and Medical Leave Act of 1993. Are there any questions on job protection? I know the earlier conversation did focus on that quite a bit.
Representative Leishman, did you ask that? I
Yeah,
believe you
thanks, Madam
did.
Chair. I was just writing down some of my thoughts here, but I think the Commissioner of Insurance said that he was going to provide us with some kind of protection language.
Yes, he did.
For those
Today,
employees.
later.
Yep.
Yes.
So that's what I'm looking for.
Okay.
Thanks.
Matt,
Brings
Please
us
continue.
to section 73 at the bottom of this page. Just again, an exception for this premium fund that we've established here, amending an existing RSA by adding a new subparagraph. Similarly for the premium stabilization trust fund. Which brings us to section 74, which is the last section of this portion of HB2, which details the 50% of premiums can be held against the business enterprise tax as a credit for the taxable period which the premium is paid. And again, we see this as a further incentive for small and mid-sized businesses to reduce their liability while simultaneously providing this benefit to their employees. And the businesses have a wide degree of latitude on how those benefits are paid for, either by themselves, by the employees, or in some prorated fashion.
Representative Hatch.
Thank you, Madam Chair. And this, I mean, probably goes along with some of Representative Wallace's questions. Have you estimated what the magnitude of that fund will be? And in other words, do you anticipate after a year 50% participation? Or I mean, you just must have some performers made out. And I would just like to get a sense of the size of that fund and what's your anticipation.
And Representative Hatch, when you say fund, are you talking about the tax credits that are held, or are we talking about the premium stabilization trust
Premium
fund?
stabilization tax credits that are held in their entirety.
So you're talking about section 74, line 3, page 40?
Yes, I am.
Thank you. Matt?
So I believe we're conflating two separate things here. So there is a premium stabilization trust fund, which is funded based on a percentage of the premium insurance tax specific to these types of policies.
Right.
Separately, and I would draw a bright red line here, businesses that opt in can claim a BET tax credit against their taxable obligation.
And my
But there's-
question first is with that. Thank you.
So your question is about the BET tax credit.
Right, what the magnitude of that will be.
Yes, and just to clarify that these monies do not go to the Premium Stabilization Trust Fund. We
I'm
did
sorry I
reach out.
conflated it. It's,
No.
but yeah. Go
No,
ahead.
no worries. We did work with DRA, and I don't know if anyone from DRA is on the line to explain their fiscal analysis, but
They were
ultimately
earlier. If
they-
DRA's on their line, would you raise your hand?
they did determine that it was indeterminable at this point. It depends on the adoption. So we do not have a specific dollar amount to cite, but DRA has been part of these conversations. And I don't know if it looks like Carolyn Lear from DRA is on.
She didn't raise her hand. Yeah, she's smart. Carolyn, are you an attendee? And if so, would you raise your hand?
Hi, Representative. Someone just gave me speaking authority.
Yes, I couldn't find you, so I thank Nancy or Mike, whoever did that.
I don't have anything to add. Matt has it exactly right. We don't have the data that would be necessary to analyze the potential fiscal impact of this BET credit because it is entirely related to the uptake rate for the program.
Thank you.
So, Madam
Representative
Chair-
Hatch, do you have a follow-up?
Yes, I do. We have some people that are pretty good in math. So what's your, I mean, when you do your RFP, there has to be some information as to the potential for participation. Do you have any of those numbers? I probably could carry the cost of the bet.
Well, I guess as far as the fiscal impact, given that this program is not operational until the second year of the biennium, it would apply to, well, I should defer to DRA here, but the taxable periods for which this credit would be eligible for would only be taxable periods ending on or after July 1st, 2024. Carolyn, do I have that correct?
She's muted. She's unmuted.
Think you have that correct. And likely the fiscal impact for tax purposes would not fall in 2023 at all, because I think it's unlikely that a business would modify their estimated tax payments during the tax year to account for what is probably a very small proportion of their overall liability. So I don't think you would expect to see the impact in 2023 at all.
Thank you. And just how many people do you expect participating in this, or do you have that number the first year and second year? And I'll stop there. Thank you, Madam Chair, with that answer.
I can see if we can work to similar adoption rates, either for similar programs, but again, anything that we would provide would be a stab in the dark. But what I would just say is, as more people join this pool, the lower the premiums would be. So we do expect this to accelerate the longer that it goes. But as far as that initial uptake, that is a very haphazard guess at this point.
Matt, I do have a couple of questions that I can't tell you I generated. I actually, as I indicated, have had a lot of comments, and some of these came from the New Hampshire Retail Association, who actually indicated they're very excited about this optional opt-in plan. One of the questions was, if the employer opts in retail, not every employee works every week. However, I don't know how many retailers pay weekly as opposed to bi-weekly or once a month. But should you have a retailer who pays weekly and you have an employee who doesn't work in that week, but who's opted in, aren't there provisions that you are not allowed to double take a weekly premium out of somebody's pay if they 1 week they work, 1 week they don't?
So I don't know if I'm the best person to speak to this, but the benefit is 60% of their average weekly wage. So I suppose if you're a business in that type of an environment where some employees work in some weeks but not others, you would probably want to extend that.
But okay, I'm sorry, I didn't word
But-
my question well. My fault, not yours. You answered a question I should have asked. I didn't. I'm a small retailer. I opt, but I have more than 20 employees. So I do opt in. But I do charge my employees part of the premium, or maybe all the premium. I don't know. But I have employees who don't work every week. I pay weekly. How do I get that weekly premium deducted?
I see with this scenario. So in this instance, the weekly paycheck would be negative is the concern, right?
Yes.
That if I make $100 in 1 week and I'm charged $2 for this benefit, I don't work the next week, I'm charged another $2.
Yes.
In theory, I owe you $2 for that. I don't know that this bill specifically addresses that concern. I think we'd be open to clarifying that to the extent that that is a nascent concern. But I would defer to someone that's better steeped in employment law than myself, though.
Okay. Then someplace in here, it refers to equivalent plans being offered by employers. And I know there are some employers in my area who are offering family leave already, but they opt to offer something like, say, 4 weeks at 100% pay, not 6 weeks at 60% or whatever. Is that equivalent? How do you define equivalent?
I would turn that to the department if I might.
Oh, I'd be happy to return. Commissioner or DJ,
The equivalent would be at least the same coverage outlined in the plan. And so it would have to be at least 6 weeks. It would have to be both first party and second party family coverage. I think if it exceeded the benefit, that would be fine. I don't know that there's any ability to call it equivalent if it didn't meet the minimums outlined in.
but if they paid more, Commissioner, than what this plan pays for a shorter period, why wouldn't that be equivalent? Let's say I make $100 a week, because I have a very simple mind. So in 6 weeks, I'm going to get $240. 60% a week is 60, 60, 60, 60, right?
360.
360. But 4 weeks at 100% gives me 400. I've gotten more money.
And what I would just say, Madam Chair, is if we could go back to that specific.
I don't want to
section.
bicker. It just came
No,
up and
no.
I got thinking about it.
Yeah, no, and that's a very good question, right? Because that's something that ultimately we want employees to receive the maximum benefits they can offer. I'm just curious how the existing language would interact or where that equivalency provision arises.
I'm not sure. I thought someplace you said it. So maybe it was opening statements.
No, and I know it is in the bill. I'm curious when that matter of equivalency ultimately comes into play. I believe it's for the individual pool. And if you're an employee, you would, in that case, choose the economic decision to not join the individual pool, but continue with your company's plan, given that
Okay,
it's
so
more.
that would be individuals only if my company didn't opt in. Am I confusing those two? I just don't remember where you said it. Flashed across my brain when somebody said it.
And I'm looking for that section as well. I'm trying to.
Okay, in the meantime, you look, maybe Representative Walls has a question that the commissioner can answer, or DJ, while you look for mine. Representative Walls.
I have two different areas I want to address, both of which deal with money appropriately. One is if we turn to page 30.
We can't hear you.
Oh. Okay, I'll speak up. One,
Oh, better.
if we turn to page 35 and we go to lines 20 to 22, it says that the department shall develop and implement an outreach program to ensure basically that people are made aware of the program. That's what that says. That presumably is going to cost money. My question is, where does that money come from?
DAS is currently budgeted for that in their insurance and risk department. They do outreaches on all of the employee benefits now, including retiree health, which has a worldwide impact. So that is part of the duties we funded in DAS.
And that duty is shared with the Department of Employment Security as well.
Okay, I just want to make sure the money's there. That's my
No,
first-
a good question, but we did fund it.
Okay. My second one actually has to go back to the state insurance premiums. So have we, if it's going to cost about $2 million.
What page are we on now, please?
I don't have the exact page, but I'm not sure I need to. If the state has to pay for the state insurance premiums for the state employees, have we budgeted that money?
Is there a statement in here that says the state must pay for all the insurance premiums for this program?
So I believe
Okay.
DAS would be working on a fiscal note, but ultimately that fiscal impact is indeterminable based on the rate the state will solicit during that RFP. We calculate and giving that $5 number that's specified in the bill, right? If that's the intent to solicit below $5 per subscriber per week, the maximum impact to the state would be $2 million. And we suspect that it will be below that and continue to fall as more private sector companies go through that adoption. So it's an indeterminable amount, but it is no more based on what we've laid out than $2 million.
Follow
Yeah.
up, Representative Walls.
Yes. Where does that 2 million come from? Where is that budgeted?
So that would need to be accounted for from DAS implementing this program. And as we always do with salary and benefits, we do see lapses throughout the year. So that would have been factored into our more conservative than previously estimated lapse figures that are contained in the governor's executive budget summary.
And that is because this is
Indeterminable.
only the second year of the biennium.
That's correct. So this benefit would only be for the second year of the biennium. And as always, we see lapses out of class 10, class 11, class 60. And as a result, that would be accounted for through lapses.
So you took a more aggressive lapse when you did your budget,
A less aggressive lapse.
a less aggressive lapse. So you are allocating, because you took a less aggressive lapse, if I get my head around this, again, I have a simple head. You took a less aggressive lapse, so there would actually be a bigger lapse, and you're expecting that could cover the second year of the insurance. Did I hear that correctly?
You did hear that correct, Representative. And turning to the governor's executive budget summary, if you look at the surplus
Oh,
statements
like I can find that with all these papers now, Matt. I mean,
on
hello.
on page 16, you see governor's recommended lapses of 92 million in FY23. You see that fiscal 21 were projected for 150 million. You see in fiscal 19 that our lapses were 147 million. So this is a conservative budget that's built intentionally. And we're more than comfortable with the lapse figures, even when accounting for this additional benefit for state employees.
Do you know how many state employees we have, Matt?
I believe we have roughly 10,000 hired and I think 11,000 and change authorized positions.
Oh, we've been unfunding them. Don't
Yeah.
worry about those.
Yeah.
Representative Walls.
Madam Chair, I presume there's a cost to develop the state pool. And I'm trying to figure out where that money is.
Okay, what page you're on now, please?
Well, let me go back to the pool here. Hang on. I'm having a hard time. Wherever the state pool is here.
Yeah, me too. That's why I was asking you the page number. We're flipping through a lot of pages. Matt, do you know the page number for that?
I don't, I can find
It
it.
was towards the end, wasn't it?
It is a little cold for a swim today, Madam Chairman, I might say.
Not the trust fund, but a pool, Mary Beth.
Line 39, page 39, line 12, is that the pool?
Page 39, line
12 to 14.
12 to 14.
This is a funding transfer, and then below on 15 to 17, the implementation of the individual pool.
So
Are you
what is-
talking about the individual pool?
Yeah, I'm just trying to figure out, so it could be,
So 15 to 17, Matt,
yeah,
39. 39 lines 15 to 17.
So that would be the individual pool for employees whose employers do not opt in.
and the question is, where does the money come from?
I think I might be able to answer that, Matt. There shouldn't be any money to administer that pool. The insurance carrier who's opting to provide this coverage is doing that as a individual insurance obligation to those members. And so it's, the pool are the folks that are opting to be in individually. And so the state's not going to be administering that.
Thank you.
But Madam Chair, it says the state treasurer shall transfer funds.
And so
That is, or go ahead,
No,
Commissioner.
that's another line above that's not related to the pool. That's 28282B:8. We are talking about the pool in 282B:9.
Okay, well, let me go back to :8. Where does the money come from?
This would be the general fund impact for the state to provide the benefit to the employees. This is a provision that allows the treasurer to transfer money to DAS for this purpose.
Employment testified that was 15,000 when they were here last week. Commissioner, I can never say his last name.
Nicolopoulos,
Kopatis, yeah.
Nicolopoulos, perfect.
Another good Greek, yes. We did have that testimony. They were, by the way, favorably leaning towards this.
Yes, and we've had extensive conversations with both the commissioner and deputy commissioner Rick Labors.
Yes, they were both on with us last week.
Madam Chair, follow up.
Representative Walls?
So, I agree the administration is small, but the implementation, that could be $3 million initially and $1.6 million a year by the numbers that I've come up with. And that's where I'm asking where that comes from.
We don't know where you're getting $3 million. And we're using a private insurance company to do this. We're not doing it in-house. It is not a state insurance. It's not a state-run insurance program. We are going to partner with the private sector and a well-established insurance company that does this for a living.
So am I to understand that there's no hit to the general fund on the cost of this program, except for an indeterminate cost for the part that employs to the state employees?
So the cost would be to provide the benefit to the extent in which state employees take it. And again, that is something that'll be dictated based on the contract of the RFP.
And the amount the state chooses to contribute to that, as opposed to asking the employees to pay, which we could pay.
So the vision here is that it's benefit provided to the state workforce by the state as written. So private employers have the option to pay or prorate.
And we're going to put state employees in it.
Yes, the state would cover their state employees.
Thank you, Matt.
Follow up?
Follow up?
So those numbers came from the fiscal note on the family medical leave from 2 years ago, because that's what the actuarial people projected.
That was actually the fiscal note 2 years ago, was something close to hiring 42 new employees over at Department of Employment Security, plus programmers to write the software for the state to run an insurance program. We are not running an insurance program. We are partnering it out. 43 million, it was 43 employees. Representative Leishman says I misquoted either the amount or the number of employees we were going to hire. So that fiscal note doesn't apply because it's a different thing. That had the state doing everything. This has the state using a private insurance company.
Okay, well, it was also in the governor's bill 730 last year. So if you look at the fiscal note for that.
I would defer to DJ on that if I might. I wasn't in this role 2 years ago. I haven't had a chance to review that specific fiscal
Well,
note, but
Number one, I haven't looked at this plan vis-a-vis the 2 years ago one specifically. I don't know as how they are exactly the same. We're dealing with this plan and we're asking questions on this plan, please.
But I'm also talking about the governor's plan. This was the second one I'm referencing was 730 was. the
We're
governor's
dealing with this year's governor's plan, not whatever was in the building 2 years ago. I did not ask DJ and Matt to bring a comparison between the two plans to see the changes. We're
And-
dealing with what's in front of us only. We
Okay.
didn't pass last year's.
I agree, but since we don't have a fiscal note, that's why I was going back to that, trying to pull up some numbers. So that was why I referenced that, because we didn't have the fiscal note here.
and if it is similar, DAS would be instructed to do a similar fiscal note, and I don't know the status of that, but I can't speak to that.
Okay, thank you.
Madam Chair, if I could, I think, the impact of this particular plan, and I believe all of us support the program or the concept of the program, but I'd certainly like to see a tightening up of the numbers, because if you just do the 10,000 state employees, I think that works out to about $2.6 million. As you said, we're looking at at least a $2 million hit, to quote you, but I'd like to see the numbers tightened up, because one of the things the chair may recall in one of the other plans, it may have been 712, the proposal was that the general funds would be returned through like a loan process, or the general funds were loaned to the program and then they'd be returned.
Yes,
As-
that was part of last year when we
Right.
were going to run the insurance program.
Yeah, so if we could at least get a better number. in
We're
the
not
general
doing that.
funds.
Well, and again, the maximum impact that we would project would be 10,000 state employees times 52 weeks in a year, times that $5 threshold that we've set. That would get you at most
2.6 million.
the 2.6. And again, we fully expect to have an RFP that comes in below that price point, that'll then be compounded by the private market, continuing to broaden that risk pool. And again, the cost to administer this to the state will decrease as time goes on and as the program is adopted by more private entities.
Thanks, Madam Chair. Thanks, Matt.
Matt and DJ and Commissioner, we thank you for being with us and listening to our maybe hundreds of questions. Representative Emmerich, do you have the last question for the morning?
Yes, thank you, Madam Chair. And I don't know who I'm asking the question of. Who's going to determine whether a company is bought into this or it's 3 employees in a company that didn't buy into it, but is remitting a check? The companies that buy into it are remitting a check. The companies that didn't buy into it are remitting a check. How are we going to know the difference?
Why do we need to know the difference?
Because if the company didn't buy in, the employees can get it for $5. If they did buy in, it could cost them $7.50.
It'll be driven by the application at employer or individual level. So once this program is rolled out, a company's going to have the option to opt in for their employees, and if they do, they'll fill out their paperwork. It'll be rated based on their risk profile, or they won't opt in, and the employees will have the right to do it on their own. And so
That answers the question.
it'll be treated no different than employers who offer other access to other benefit insurance products. An AFLAC is something you might be able to relate that to. Your employer may offer you access to products. And so.
Thank you. So I guess the answers are going to ask them.
Yeah, so Representative Emmerich says that answers the question.
Thank you.
All right. Representative Hatch,
I just want to clarify.
I think I have a potential resolution to your issue with section 1 in HB2 that I want to discuss with the group. I want to take, however, a short 10-minute break. We have all been sitting in our chairs for 2 hours. So if Tracy is going to mute the room, I would ask the participants at home to mute and block your screens. We'll be back at approximately 4 minutes before 11. Thank you, everybody, for participating. Thank you for coming. And we are going to be in recess for 10 minutes. Thank you.
Madam Chair, I have one more critical.
We are in recess. Representative Walls. Back. Matt is still with us. Matt is a new member of Division 1.
Don't tell Division 2.
I won't tell Division 2. When we were leaving, Representative Walls had a question. Representative Walls, are we live, Tracy? Are we? Representative Walls, do you still have a question?
I actually called Commissioner Nicolopoulos on the break and he did address it. So
Okay.
I will tell you that. But however, there's something going on here where it says you cannot start your video because the host stopped it. So that's why you don't see me.
Nancy and Mike, have we?
There, it's back. Somebody just.
Okay, you're back. Sorry, I didn't do anything. It's magical.
I know, but I just thought I'd mention that, so yeah, I spent the break on the phone with the commissioner, so.
Okay, all right. Matt, we have the rainy day stabilization fund, which is yet another of your sections in HB2. Can you tell me what page you're on and what section it is? Because we were going to talk about that.
So we're on page 40. This is section 77.
Okay, page 40, section 77.
This is lines 20 to 25, and this is hopefully a much briefer conversation than the last one, but I'm happy to answer any questions that may arise. The intent here, and it's just a one-word change, that changes the cap of the Revenue Stabilization Reserve account, or the rainy day fund, to an amount equal to 10% of unrestricted general fund revenue over the biennium. Currently, our cap is 10% of a single fiscal year. And the impetus behind this change really does speak to the revenue shortfall we forecasted at the beginning of this pandemic. We felt that this cap was overly restrictive for a type of event that, absent what turned out to be a robust recovery, the state would have been in a very difficult spot. So this does not automatically require the state to put any additional funds into the rainy day fund, but rather allows us to put essentially up to $320 million there if we ever were to so choose. The current statute limits us at roughly $160 million, which means we're almost full, given that we're at $115 million today. why would we want to do this? I think the biggest thing to highlight is that when it comes to managing through a crisis, the state should have sufficient reserves to make sure that we're able to steer through it. We budget on a biennial basis. We think it makes sense to tie the rainy day fund to a biennial basis as well. Separately, this does impact our bond rating. And I do have a report from Pew Charitable Trusts that I will share with the committee digitally as well. But New Hampshire's bond ratings are very strong, some of the strongest of any state in the country. But what I would say is that, and this report does detail it, there's opportunity for the state.
Jerry, can you get that report? And Matt, do you have it digitally to either quickly zip to Michael Kane or Michael Hoffman or Nancy so that the people can see it at home?
Absolutely. And I'll send that as soon as we conclude here. But essentially that it's not a function of what percentage of the rainy day cap is funded, but rather how much money the state has.
This is one copy, right?
This is one copy.
I am going to have Janet Clayman make copies of this for everybody and email and snail mail it out to Mary Beth and Bill. We haven't seen it either, but we will get electronic copies hard copies for those of us sitting here. Mary Beth and Bill, you will get a copy of this in the mail afterwards, best I can do at the moment.
And I can email the link online as well.
Great, thank you. Tell her
Madam
Devil's
Chair,
Fire. Yes,
I just have a quick, simple question. What does it do to our bond rating? Does it raise it or lower it? How does it?
I think
affect
that's
our-
what he's about to tell us, and we just
Should
don't have
raise it.
copies
Yeah,
of the Pew
So
report.
the benefit, of course, is bond ratings are assessed based on how well the state is prepared for an adverse financial impact. Anything that the state can do to better prepare itself, such as putting a higher cap on the rainy day fund and allowing us to accrue more money there. And if you think back to 2 years ago, when we had such a robust surplus, we were trying to find one-time projects to spend it. It would have been fortuitous to maybe put a bit more of that into the rainy day fund for the potential crisis. This would simply offer that additional flexibility to the legislature to put additional money in the rainy day fund. It doesn't require anything to go there.
So your answer is this would strengthen our bond rating in response to Representative Walz's question. What does it do to our bond rating? Is that correct?
Correct, but it doesn't directly do that because the state would have to actually put money there to see those benefits, but allows additional flexibility for the state to do so. And if the state were to do that, it would likely have a positive impact on.
Follow up, Representative Walz.
No, I think he just answered my question, and that is raising the rating doesn't, raising the cap doesn't change the bond rating. It's if we fully fund it that changes the bond rating.
Correct. And there's not a magic number or a percentage, right? It's a holistic review of the state's finances, but being better prepared for an economic downturn would have some positive impact. It may be de minimis, given that we're already on the upper end of those ranges compared to other states. New Hampshire is very strongly rated by all three rating agencies, S&P, Moody's, and Fitch. But again, this is just a good management structure that would allow us to steer through a crisis if COVID had not rebound, or the large multinational companies that have continued to pay our business taxes predominantly hadn't rebounded as robustly as they have.
Okay.
Sure, but wouldn't it then lower our borrowing costs? If we fund this, doesn't it then lowering our borrowing costs for everything we do in our capital budgets?
If our bond rating improved, whether for this factor or any other factor, as part of a good management of state finances, yes, that would have that. But I will say that the returns may be de minimis, given that we're already on the upper tier of that range.
Thank you.
Please continue. All right, Deb, you said everything you want?
That's all I have. Again, this really just aligns the rainy day fund with our biennial budget is the
Okay.
biggest takeaway.
Representative Leishman?
I only have one question, Madam Chair. Would you accept a motion to approve?
I would, Representative Leishman. Representative Leishman moves to approve. I will second that motion. On the motion to approve section 77, the revenue stabilization cap in HB2. If you're in favor of the motion, when your name is called, please say yes. If you're opposed, please say no. Representative Emmerich is going to call the roll for us. What we know about Representative Burge is he got his second shot yesterday. We don't know if he's having a reaction or sleeping or what, because he intended to be here. We did try to call him. We got no response. We did text him. We've got no response. So we're hoping that his second shot has just made him sleepy and he's not had a car accident on his way in or something critical, but we've heard nothing bad. So we're hoping for the best. So Representative Emmerich, when you're ready to call the roll. Yes. Okay, so far, three of us have voted yes. I voted yes. Representative Griffin voted yes. Representative Emmerich just turned on his microphone. We're slow to be trained, but we're learning.
Representative Leishman,
Yes.
Representative Hatch,
Yes.
Representative Walls.
Yes.
Madam Chair, the vote is 6-0 in favor.
Vote is 6-0. Matt, thank you for coming with it. We are not doing anything with family leave this morning. You gave us a lot to think about, but it is not something we're going to do at this time. I would like to have the committee turn to section 55 in HB2. Which is found on page 26. All right, section 55 is the distribution of rooms and meals. And as you know from previous conversation, Mrs. Levinas researched this extensively and found out how complicated it was and how deep it was. This has been in HB2 for every, I think, all the 8 years I've done budgets in House Finance. The final result was Mrs. Levinas thought, and I agree with her, we should leave it in. It is much too complicated, probably requires a policy bill to make a change. And I'd like to welcome Representative Weiler, who is going to sit in with us for the rest of the morning. It's nice to see you, sir. And there's a microphone right there to turn on. We're just about to vote in the distribution of rooms and meals tax, which is a section that's been in HB2 for a number of bienniums. And I would move to approve this section.
Section number, please.
Representative Emmerich seconds on the motion to approve section 55 in HB2. If you're in favor, you'll say yay when your name is called. If you are opposed, you will say nay.
Representative Over.
Yes.
I'm a yes. Representative Weiler,
Yes.
Representative Griffin,
Yes.
Representative Leishman,
Yes.
Representative Hatch,
Yes, Madam Chair, if I'm just making a comment after the voting. Thank you.
Representative Walls.
Yes.
Representative Hatch, I think you stuck your hand up and I did not see it. My sincere apologies.
No, not necessary. I certainly understand. I just wanted to note that rooms and meals, the hospitality industry is vitally important to this state.
Yes.
And that mechanism to fund the promotion of that activity through a portion of the rooms and meals tax was great and very effective. And I'm just, though I voted yes, I had to really contemplate this pretty hard. And my first inclination was not to vote yes, particularly where we're reducing the amount of the rooms and meals tax. And I just, my concern is that it's very counterproductive, but in the sense of cooperation, I voted yes, and hopefully we can address this in the future and bring it back as soon as possible. Thank you, Madam Chair, for your indulgence.
Okay, I don't think we reduced the amount of rooms and meals tax. This section says the provisions of RSA 12-011B, creating a portion of meals and rooms tax revenue to the Division of Travel and Tourism Development are hereby suspended for the biennium ending June 30th, 2023. I think the intention was not to reduce, but if they got more, especially given the pandemic, when rooms and meals tax has been lower, that they could support that industry. And I couldn't agree more with you that that industry is vital to us, Representative Hatch.
Thank you, Madam Chair.
All right, we have two amendments, and I have to credit the diligence of Representative Walls to start them. Could LBA bring up on the screen the Shea Farm amendment for the Department of Corrections? Gentlemen?
Madam Chair,
Yes.
given that your amendment apparently is broader than mine, would it make sense for me to withdraw my amendment and just use yours?
I got them in two pieces so we could use them both. The next one is the second transitional housing.
So yours is only one unit and mine's only one unit. Is that correct?
Yes, they had already started on yours by the time I worked this out with Helen in the afternoon. So we left it with yours and added mine. So you'll see a second amendment very shortly.
Thank you for the explanation.
So this, this division was, all of us, a bit distraught about the cuts to Department of Corrections. We've restored vocational training and education. This would restore the cuts to transitional housing, Shea Farm. I'd like to thank Representative Walls for pushing that. This might not have happened had she not done that last Thursday. So Representative Walls, might I assume you would move to approve this amendment?
You most definitely may assume that, Madam Chair.
I
And
will
I
second
second.
that motion. Okay, Representative Hatch seconds that motion.
Thank you, Madam Chair.
Thank you both. So on the motion to restore the funding for Shea Farm, if you are in favor, when your name is called, please say yes. If you are opposed, please say no.
Madam Chair, would you like me to speak to the amendment briefly first?
Yeah, sure you could.
All right, so what I did with this is we had to find money. So I pulled the money out of the budget for the courts and there was.
Yeah, but that's not going to happen. I
Oh.
funded both of them without.
All right, then I'm going to be quiet.
Okay,
Representative Ober,
yes.
I'm a yes. Representative Weiler,
Yes.
Representative Griffin,
Yes.
Representative Leishman,
Yes.
Representative Hatch,
Yes,
Representative Walls.
Yes,
Madam Chair, the vote is 7-0.
Motion, the vote is 7-0. And LBA, if you can bring up the second transitional housing amendment, which is a companion to this. That wasn't good throw. With the second amendment, we will fully restore the funding to DOC's transitional housing. And this goes along with the Shea Farm amendment we just voted. And basically, so you know how we funded it, I talked to Representative Umberger. She was going to make a cut in HB2 that gave us enough money to fund both of these, still meet our cut goal, and still restore both of these. And I actually really started working on that Friday because of the push by Representative Walls. And I knew she was working on it because I'd asked her to. And then in the afternoon, when Helen sent me this, I called Karen, we had a conversation. We have the money to fund it. So I am going to move to approve the addition of transitional housing in Manchester and to approve the DOC budget with the completion of this. We will have another budget done. Is there a second?
Second.
Representative Emmerich seconds. If you're in favor of approving the amendment to restore the housing to Manchester transitional housing and to approve the DOC budget, You will say yes when your name is called. You will say no if you're not. Representative Leishman, comment.
Yes, thanks, Madam Chair. And I know I speak for all my colleagues on both sides that we really appreciate your efforts on this, and it has not gone unnoticed. Thanks.
Thank you.
Madam Chair,
Yes,
I'd like to second that, but I also have a technical question. And that is, given that we just approved my amendment, and I honestly don't understand how these work. This is a true legitimate question. Given that I had indicated to do a back of the budget cut to the judiciary, and we're now approving this with a separate cut in HB2, how does that work with two different funding sources? Or is my attempt to do this from the back of the budget cut from judiciary, is that not in writing, or what's?
your back of the budget cut is not being voted on. I sent it back to LBA this morning.
Oh, so that would have been a separate amendment?
Yes, ma'am.
Now I understand. Thank you for helping me understand.
You're welcome. Representative Emmerich, when you're ready, please call the roll.
Representative Ober,
Yes.
I'm a yes. Representative Weiler, I'll get it out. I
Yes.
looked down, saw the birds. I'm like, wait a minute. Representative Griffin,
Yes.
Representative Leishman,
Yes.
Representative Hatch,
With a preponderance of gratitude to the chair, I vote yes.
Representative Walls,
Most definitely, yes. With great thanks to the chair.
and chair the vote is 7-0.
Vote is 7-0. I have to tell you that, and I didn't watch the news last night, so I don't know if Adam Sexton got this on or not, but he called me about this, and then he called me back, wanted me to do a Zoom, and when I did the Zoom, I made it very clear that Representative Mary Beth Walls pushed us to look in this direction, and that the division, and I named all 7 members of the division, have been working very hard to get the budget done, and we were all unanimous about this. So I made it very clear this was a team effort and not just my effort. And then I was going to watch the news.
It didn't. make
Only somebody called me about the training and vocational education in the corrections. And by the time I got off the phone explaining, we had put all that back, news was over. So Tracy says it didn't get on.
Didn't get on.
Madam Chair, I also spoke with Adam Sexton yesterday, and he indicated to me he was always planning on putting it on today, not yesterday. So I think
Okay.
it's a day early.
Well, he called and asked me if I wanted to be on. I said, no. He said, don't you want credit? I said, never. It's a team effort. He said, oh, well, I'm sure you want no. And then I said, yes, I'll do it, because it was important that people know we did this. Now, let me see what I have next. Representative Leishman, you're on the hook. LBA, will you please bring up 2021-0806H? This is an amendment by Representative Leishman that I do think we all support. This is about Section 19 and HB2.
So, Madam Chair, I think I forwarded you an email I received by our former colleague, Representative Spanos, concerning this item, and he was very appreciative of our efforts. Again, for Representative Weiler, who may or may not be familiar with this, this is the change giving the governor the complete authority to dispose of the property in Laconia. As I'm sure that all of us recall, Representative Spanos and Mr. Ball were very supportive of establishing this redevelopment planning commission. They've been working, so they felt kind of undercut and surprised by the proposal, basically to eliminate them and take the authority away from the Department of Administrative Services to work with them on the sale of the Laconia property. So I think that covers it, Madam Chair.
Very good.
I don't see any questions. Representative Leishman, would you like to move your motion?
Thanks, Madam Chair. I'll move it.
Representative Leishman moves. Representative Emmerich seconds. If you're in the favor of amendment 2021-0806H to replace section 19 and 18 in HB2, please indicate by saying yes when your name is called. Otherwise, say no.
Representative Over.
Yes.
I'm a yes. Representative Wyatt. Yes. Yes. Representative yes. Representative Hatch,
Yes.
Representative Walls,
Yes.
and then vote 7-0.
The vote being 7-0, we have approved section 19 and HB2. Now,
Madam Chair, did we approve that or did we just approve the amendment?
the amendment replaces.
Got it? Thank you.
Okay, Mike and Nancy, can you bring up the sheriff reimbursement for me, please? My reaching towards. Mike, did you give me an HB2 amendment to go along with this? I'm looking at the HB1 amendment. Is there also an HB2 amendment?
Yes, we just received the HB2 amendment this morning, and I'm going to share it on the screen.
Okay, why don't you bring up the HB1 amendment first, and then we'll do HB2. All right, so HB2 had a section with a proration of the money. The sheriffs, every biennium I've been on finance, have been a burr under our saddle in Division 1. And that burr has gotten bigger with the implementation of felonies first. It used to be before felonies first that the majority of those arrests went first to district court. They were arraigned using video arraignment, i.e. no transportation of prisoners. When felony first implemented, Superior Chief Court Justice Nedow did away with video arraignments. And now in every county, and of course Hillsborough, where I live and where Representative Leishman lives, has 2 courthouses. So we have double the effort and double the sheriffs involved, have to do in-person arraignments, lots more transportation. Since I was digging into things for Representative Walls on Friday, I was just kind of in a roll. What are our other little horses that go out after dark? What are the nightmares we've had that we haven't been happy with? And I kept hearing Representative Hatch and Representative Taberge's voices in my head about Section 1 in HB2. So I had Nancy dig up the RSA for me. Surprise to surprise, the RSA never said the DAS would pay this. So it's always been available for the judicial branch to pay. Surprise, surprise, the RSA does have a statement that says up to the funds allocated. So we have a situation that we created one time trying to be good that said, we're going to have DAS reimburse this and we're going to have them do it for the judicial branch. Judicial branch never has any visibility of the funding, never has any visibility or idea of the consequences of their requests, such as cutting off video arraignment. And now we have this disconnect and the sheriffs are very unhappy. And 2 of our representatives on this division were very unhappy. This Amendment 1, which is on the board, will move the money into the judicial branch. The Amendment 2 that will follow this, which Mr. Hoffman said he would share on the screen and which none of us have seen yet, except I know what it's going to say, specifies in the RSA that the judicial branch is responsible for the reimbursement, so we don't have this disconnect again. And it also specifies that the judicial branch will explore using more technology in order to cut down on some of the transportation costs. We could go back to the video arraignment, for example, in Superior Court, without a doubt. All of us have county prisons that are set up with video rooms. So Mr. Hatch, I am getting rid of that horrible amendment you and Mr. Taberge didn't like. I'm putting the funding over there. We did not cut the judicial branch in any way. So, and we gave them transfer authority in HB2. So we know they will always have funding to 100% fund the sheriffs. Mr. Hatch, your hand is up.
Just again to thank the chair for her very good and well-intended efforts. And this is a work in progress. And again, I can't thank you enough for your attention. That's all. Thank you.
You're welcome. I'm going to move to
Madam Chair.
Representative Weiler. Representative Weiler's hand was up first. Representative Waltz will be
Sure.
second.
So there's nothing in the amendment that talks about the rate they're being paid.
The HB2 has a second amendment that addresses paying them vis-a-vis the contract. And that is in there all the time. We have approved that. So that RSA at some point needs to be fixed to match what we're doing in HB2. But we have already approved that. Representative Walls.
Thank you, Madam Chair. I'm looking at HB1, which is relevant for this purpose because it specifically says the state shall reimburse the sheriff's office for court security. So this is not necessarily transportation. This is actually court security in the courtroom during the day. I'm not arguing that we shouldn't necessarily put it on the courts, but I'm just saying that in this case, it's not about the transportation of the prisoners. It's about the security in our courthouses.
It's the transportation that has upped the cost that is causing the heartache because of the lack of the video arraignment with felonies first. So we always had enough money to cover the courthouse, but it also covers the transportation, and the transportation has gone up significantly. And I think Mr. Hatch and Mr. Taberge both talked about the extreme distance that you have to drive sometimes up in the northern counties. So that means more hours, more half days, more full days, because they transport the prisoners and then they provide the security. If the prisoners are not transported, then they do not have people in the rooms to provide security for. So it kind of all goes together, but we know where the increase came from, that we started having the dollar amount problem. Representative Hatch.
Madam Chair, if I can
Yes,
talk-
thank you, Madam Chair. Not to belabor this, but just that we have requested information from the courts that's forthcoming that will give us viable factors to utilize to be fair with this, other than just population or other things. There's a lot of factors involved, and I would appreciate anybody's input or help in establishing viable factors. That's all. Thank you,
Yeah.
Madam.
And I think that's good. You can continue to look at that. What this does is
Right.
go back to the model where everybody was getting paid 100% while you do your investigation, instead of shorting some sheriff's departments money for work they're doing, which I agreed with you did not seem fair.
Thank you.
Madam Chair,
Yes,
to be clear, just going back to HB2, there's two different provisions, one on court security and one on prisoner custody and control. Would this fully fund both? Because I've heard from my own sheriff as well as other sheriffs about the fact they can't hire people even at the current rate. And taking it down to $80 means they're not going to be able to hire anybody. So I just want to make sure we're fully funding both sections.
the current rate is another section HB2 that we've approved that says that they are paid at the same rate as the negotiated contract. And
Right.
that's an HB2, and we voted that in earlier.
Okay, I'm just
Okay.
trying to understand.
So I'm
that-
going to move the amendment to HB1. Representative Emmerich said he would second. If you're in favor of the approval of HB1, when your name is called, please say yes. If you're opposed, please say no.
Representative Ober,
Yes.
I'm a yes. Representative Weiler,
Yes.
Representative Griffin,
Yes.
Representative Leishman,
Yes.
Representative Hatch,
Yes,
Representative Walls,
Yes.
Madam Chair, the board is 7-0.
Vote is 7-0. Mike, will you share the HB2 amendment for this and tell us what the number is?
I will, but may I ask a question?
Yeah,
I just happened to notice on budget page 76 for that sheriff's reimbursement, there is a footnote So we would take the committee's action as also deleting that footnote. Just
Yes,
wanted to.
please. Absolutely. Okay, we now have amendment 2021 0837H, which does what I explained when I gave my explanation about the bundle of HB1 and HB2 together. So this tells the judicial branch to seek to use the technology that is appropriate. And it also tells the judicial branch that they will be reimbursing the sheriffs for all of these fundings, which seems appropriate because the judicial branch is the one determining how much security they need, not DAS. So again, I am going to move to approve Amendment 2021 0837H. Representative Emmerich seconds. Seeing no discussion, Representative Emmerich, when you're ready, if you're in favor of the motion, please say yes. If you're opposed, please say no.
Representative Ober,
Yes.
I'm a yes. Representative Weiler,
Yes.
Representative Griffin,
Yes.
Representative Leishman,
Yes.
Representative Hatch,
Yes.
Representative Walls,
Yes.
and the vote is 7-0.
Okay. The vote is 7-0. We have a couple of budgets that we could move to approve. The legislative branch, although it falls under us, the RSA actually says that Facilities Committee determines it. So we could move to approve that. We have also had Treasury in, and we could move to approve the Treasury budget. Is there a motion? Representative Leishman moves to approve Treasury and the legislative branch.
So second,
Representative Griffin seconds. If you're in favor of approving the two branches when your name is called, please say yes. If you're opposed, please say no.
I gotta catch up with you.
And Representative Emmerich is
All right.
typing as fast as he can with these little crayons, so just bear with him till he gets ready.
Thank you, Madam Chair. Representative Ober,
Yes.
I'm a yes. Representative Weiler,
Yes.
Representative Griffin,
Yes.
Representative Leishman,
Yes.
Representative Hatch,
yes.
Representative Walls,
Yes.
and the vote is 7-0.
The vote is 7-0.
Let's
I
hope
have-
the steps get completed timely.
Yes. I have a
Really?
bundle of two amendments. We are going to amend HB2 by replacing section 60. This is amendment 2021 0805H. And then it has a companion HB1 amendment that is coming up. Mr. Hoffman, will you speak to this amendment, please? Representative Hatch, I'm sorry, your hand is up.
And I'm sorry it was.
Okay. So on amendment 2021 0805H. Mr. Hoffman is going to walk us through this, I hope.
Yes, amendment that's on your screen, 805H, changes section 60 to read that the grants for state aid, which is water projects, are suspended for the biennium, including existing and new grants. I'm paraphrasing a little bit there. Then section paragraph 2 provides that in the event of general fund unrestricted revenue coming in above plan, the Commissioner of the Department of Environmental Services, with the approval of Fiscal Committee and Governor and Council, can request additional general funds to make grant payments. The Commissioner can make those requests every 6 months for the biennium, and the additional appropriations shall not exceed 50% of the amount over the plan. the amount of revenue over the plan.
Thank you, Mr. Hoffman. I would move the approval of Amendment 2021-0805H. Representative Emmerich seconds. Discussion. Seeing none, if you are in favor of the amendment, when your name is called, please say yay. If you're opposed, please say nay.
Representative Ober,
Yes.
I'm a yes. Representative Weiler,
Yes.
Representative Griffin,
Yes.
Representative Leishman, Representative Hatch, Representative Hatch,
You're muted.
Sorry, yes, sorry.
Representative Walls.
Yes.
Madam Chair, the vote is 7-0.
Thank you. Mr. Hoffman, would you bring up the HB1 amendment that goes along with this, please?
Yes, is it visible to you now?
It is. Thank you. It may have been before. I was looking down. I not only need eyes in the back of my head like every mom, I need a third one right in the middle of my forehead to look up and down at the same time. So this amendment completes the action we just took. And with this amendment, I'm going to move to approve HB1 amendment as well as approve the DES budget as amended. Representative Emmerich will second. Seeing no discussion, when Representative Emmerich is ready to call the roll, if you're in favor of the amendment to approve HB1 amendment and the DES budget as amended, you will say yes. If you are opposed, you will say no.
Representative Ober,
Yes.
I'm a yes. Representative Weiler,
Yes.
Representative Griffin,
Yes.
Representative Leishman,
Yes.
Representative Hatch,
Yes,
Representative Walls.
Yes.
Madam Chair, the vote is 7-0.
The vote is 7-0. Zipping right along with the speed of a small elephant. Better than a small horse. Yep. When you have a nightmare, you have a nightmare. You got to do what you can. Yes. Okay, I have an amendment for HB1 that we have clearly discussed. And that is to restore the funding to the Small Business Center at the amount of $225,000 in each of the 2 years for the biennium. And LBA is going to bring that up on the screen so everybody can see. This is something I think the division was united in doing, and this fulfills our promise. See, they're struggling as much as we are with paperwork. They're making me feel better. Here we go. So as you can see, we're doing, as we discussed previously 2 or 3 times, restoring the Small Business Development Center funding, $225,000 in 22 and again in 23. And I would move to approve. Representative Emmerich moves to second. Discussion. Seeing none, Representative Emmerich, when you're ready, you can call the roll. If you're in favor, when your name is called, please say yay. If you're opposed, please say nay.
Representative Ober,
Yes.
I'm a yes. Representative Weiler,
Yes.
Representative Griffin,
Yes.
Representative Leishman,
Yes.
Representative Hatch,
yes,
Representative Walls.
Yes.
Madam Chair, the vote is 7-0.
Okay, Mike, we have the second BEA HB1 amendment. If you can bring that up on the screen, and I'm not sure if that's you or Nancy to talk to it. We have so much paperwork, I've lost track. You guys have both done great jobs.
Madam Chair, what's up on the screen was page 2 of that change, which reduces the funding for marketing within travel and tourism to pay for that.
Thank you, Nancy. The second part of that amendment we just voted, as you know, we took the money out of travel and tourism. Nobody wanted to do that. The good news is the Biden COVID Act with lots of things in it besides COVID relief, has money for travel and tourism. The governor and the governor's budget director have confirmed that there will be money coming from the feds. We don't know how much yet, and they haven't seen the strings yet, but there will be money to beef up our hospitality situation. The governor's budget director is still sitting in the room. He's shaking his head yes. So we are aware that we are going to do that. This second screen was included in the first vote. Thank you for pointing that out, Nancy.
You're welcome.
Now we have the unfunds, the vacant position.
Getting there?
I believe that's the one that I just posted on the screen, Anthony.
It is. You guys are magical down there. I don't know how you keep it up. We have an HB2 amendment, which I think you guys brought up to me in this sheaf of paper.
Madam Chair,
Yes, Nancy.
you approved that 0738H amendment
Oh.
last week.
Thank heavens, I can't find it. That makes me
So
feel
that's
good.
why. And
Ay, ay, ay.
essentially, what that did was delay the start of the hiring of an unclassified position, Director of Intergovernmental Affairs, till January of 2023. But in and of itself, it doesn't save any money because the money would be transferred from a vacant position within DBEA. So this is the piece that makes that savings, if you will, happen.
Yeah,
By
it's okay.
unfunding the position until that point in time.
Thank you.
You're welcome.
I can't tell you how much I miss having the two of you here with us. I try not to whine too much, but I think I mention at least once a day. So,
Twice.
and we all agree with that, in case you want to know, that thumbs go up around the table when I say that. So it's a universal whine in this room. All right, on the motion to complete our action that we started last week, if you're in favor, I will make the motion. Representative Emmerich seconds the motion. I don't see any discussion. If you're in favor of the motion, please say yes when your name is called. If you're not, please say no.
Representative Over,
Yes.
I'm a yes. Representative Weiler,
Yes.
Representative Griffin.
Yes.
Representative Leishman,
Yes.
Representative Hatch,
Yes.
Representative Walls.
Yes.
Madam Chair, the vote is 7-0.
All right, and with that, I move to approve the BEA budget as amended. Representative Griffin seconds. If you're in favor of the motion to approve the BEA budget as amended, you'll say yes when your name is called. Otherwise, you will say no.
Okay. Representative Over,
Yes.
I'm yes.
Yes.
Representative Weiler,
Yes.
Representative Griffin,
Yes.
Representative Leishman,
Yes.
Representative Hatch,
Yes.
Representative Walls.
Yes.
Madam Chair, the vote is 7-0.
Vote is 7-0. The budget is approved. LBA, will you bring up the HB1 amendment to add the 2 auditors to DRA? Just to remind you, this amendment will ensure that we have another $3 million in revenue that was not in the revenue estimates.
This is HB1.
This is HB1 amendment.
Question.
Representative Weiler,
Do you remember how many auditors they have?
no.
Seemed like every budget we've added some.
This was, they have a lot of vacancies
Ah.
and they've unfunded some people.
Yep.
And to meet the governor's projected plan, he didn't take into account their revenue and he took out 2 more and we're restoring them
Does it make money?
because they make money and we need the
Oh,
3
yeah.
million bucks. I am going to move to approve the HB1 amendment, adding 2 auditors and to approve the DRA budget as amended. Representative Emmerich is seconding. We've discussed this, so I don't see any additional hands up on the motion to approve the HB1 amendment and to approve the DRA budget as amended. If you're in favor, please say yes. If you're opposed, please say no.
Representative Ober,
Yes.
I'm a yes. Representative Weiler,
Yes.
Representative Griffin,
Yes.
Representative Leishman,
Yes.
Representative Hatch,
Yes.
Representative Walls.
Yes.
Madam Chair, the vote is 7-0.
The vote is 7-0.
I got to get some more.
Right on the back. Jen will do it for you.
All right.
Sorry, I only had 10.
All right, we have section 159, page 68 in HB2. For some reason, we just hadn't approved. Representative Leishman moves approval. This is the Judicial Council expenditures,
We're looking for HB2.
and I will second that. Discussion? Seeing none, Representative Emmerich on the motion to approve section 159 for the Judicial Council and HB2. If you're in favor, please say yes when your name is called. If you're opposed, please say no.
Representative Ober,
Yes.
I'm a yes. Representative Weiler,
Yes.
Representative Griffin,
Yes.
Representative Leishman,
Yes.
Representative Hatch,
Yes.
Representative Walls.
Yes.
Madam Chair, the vote is 7-0.
Okay. Mary Beth, I think I have another one of your amendments. Can we bring up 2021-0813H?
Madam
This
Chair, I need-
is, this is your amendment, Mary Beth, that you've been working on with Kim Merrifield on that section 128, the language that there was a concern about. So
So
this
I don't-
has your name on it. Think you
I-
have a
I'd
hard
like to
copy.
move it and speak to it.
Yep. I will second your motion.
Thank you.
Representative Walsh moves and Representative Ober seconds, and Representative Walls is going to speak to her motion.
So this amendment is not exactly the language that I wanted. Commissioner Merrifield came up with language that I thought was better, and then OLS said you can't do it. So I kind of view OLS as God in these things, and God had spoken. So I worked with OLS to come up with additional language. As you may recall, the problem is that they're stopped sending notices, return receipt requested. And therefore, they have no idea if the service has been completed upon people from whom they want to take away benefits. And I think that you should not be taking benefits away unless somebody's been notified. So this happens, and I wasn't even sure of this when I started this. This happens to apply to workman's comp. And in most cases with workman's comp, there's been a decent back and forth. But if somebody moves and they, for whatever reason, don't have a forwarding address or don't have a fixed address to have a forwarding address, I wanted some time to happen. So what it says is, you can read it, but what it basically says is that if you don't have service, you have to do it, send a return receipt requested. If that doesn't happen, it gives the department a year to try and find the claimant and notify them that there's going to be some sort of problem with their benefits. And that during that year, they're supposed to make appropriate attempts to contact the claimant. And if at the end of the year, they can't find the claimant, then they can just issue an order not in favor of the claimant. In other words, where the claimant loses. And it seemed to me that this was a reasonable compromise, kind of a fair compromise of protecting the claimant, but not leaving a DES or in a situation where they've got cases open forever. So that was how we came to this language.
I don't see any questions. Representative Walls, can I ask you to amend your motion? Would you move to approve this amendment and to approve the Labor Department's budget, since this will close that out?
I do. I hereby move both the amendment and the budget.
Okay, I will second both of those. If you're in favor of approving Amendment 2021-0813H, you will say yes when your name is called. If you're opposed, you will say no, and the clerk will call the roll.
Representative Ober,
Yes.
I'm a yes. Representative Weiler,
Yes.
Representative Griffin,
Yes.
Representative Leishman,
Yes.
Representative Hatch,
Yes,
Representative Walls.
Yes.
Madam Chair, the vote is 7-0.
Okay. I have one last little bundle we're going to do. It's two amendments. The first one is 2021-0800H. We're going to be on page, I think, 53 or 54 with the parole board.
HB1 or HB2, Madam Chair?
HB2, I apologize.
Thank you.
Oh, I give you that too.
It's extra too.
Did you both get one?
Yeah.
Mike, you have it up on the board. Thank you. Okay. The governor, section 122, if you're looking at, the governor has proposed, and by the way, this has gone to Carol McGuire at eDNA and has the eDNA seal of approval, which I got back Monday. Line 29, the adult parole board shrinks from 9 to 5, 2 of which shall be attorneys. There's a composition of the board, doesn't stay, doesn't have any change. Most of this is existing language. However, we get down to page 2, line 1. The governor was proposing 30,000 a year without mileage. I've lowered that annual stipend to 20,000 a year, keeping in mind that we are making small cuts to get through the years. The board will hold 36 days of hearings, et cetera. So all of that is the same except the stipend. Representative Leishman moves, Representative Ober seconds the approval of motion amendment 2021-08H00H. Somehow that's hard to say, 0800H. Okay, Representative Emmerich, have I stuttered around long enough? You can call the roll.
Does that include the budget of?
No, it does not. I have another amendment.
Oh, okay. Representative Ober,
Yes.
I'm a yes. Representative Weiler,
Yes.
Representative Griffin,
Yes.
Representative Leishman,
Yes.
Representative Hatch,
yes,
Representative Walls.
Yes.
Madam Chair, the vote is 7-0.
Okay. 7-0. The next section, turn the page to page 1 to page 55. And we're going to delete with amendment 2021-0794H. We are going to delete the director of operations as a from this point. I think, Nancy or Mike, who did this? Previously, we made that person 50% and adjusted the salary in DOC. Is that correct? Or did we just delete this person altogether? This is the new position. Never mind, I remember. This is the brand new position for the biennium. They're just going to have to do without him. It adds too much cost. Again, you had to
Madam
do
Chair,
something. Yeah,
excuse me. The position.
please help.
The position exists as a executive assistant now. And this
Right.
would, the name of the position to Director of Operations. And when I looked in the system, the salary is very close for the two. This would be more of a formal naming of that position as
Yeah.
opposed to actually.
This did not have a policy review which eDNA should have done. So they can file a bill next year. They can run through eDNA. eDNA can look at it. So I move to approve section 2021-0794H.
Second,
Representative Emmerich seconds. Seeing no discussion. Will the clerk call the roll?
Representative Over,
Yes.
I'm a yes. Representative Weiler,
Yes.
Representative Griffin,
Yes.
Representative Leishman,
Yes.
Representative Hatch,
Yes,
Representative Walls.
Yes.
Madam Chair, the vote is 7-0.
All right, the vote is 7-0. We have lots more work. We aren't going to be doing it today. We have the public hearing starting at 1 o'clock. I think Representative Weiler and several people are going to be in Reps Hall. Several people are going to be hybriding in remote.
Is that today?
That's today, isn't it? That is
Yep,
today.
today at
Please
1
tell me
o'clock.
that is
I need
today.
timekeepers.
I think we'll be done with the majority of our work tomorrow. And if you're sitting in this room, check your email, make your lunch order with Nancy. Lunch is on me. Mike Hoffman, Mike Kane, you should check your email, get your sandwich order to Janet. Lunch is on me. Nancy, if you want to come in, it's on me as well. I just don't have any way of emailing you a sandwich. Although Bill Hatch is helping me figure out how to email him some Beefeater's gin. So we got that working. I don't know what Mary Beth has got in hand, but something. I did post a hearing a week from today. And the reason is Representative Major is working diligently tomorrow on new revenue estimates. He is also working on the tax sections in HB2 that belong to us. He will be able to tell us where he and his committee stand on that, so that we can go ahead and finalize our work next Tuesday. Oh, I had one more amendment I wanted to vote in before we go, so don't hang up. Now I'm leafing through my paperwork like crazy.
Amazing you can keep track of it all.
Ay. Well, it took, here we go. Mike, I'm going to bring up 2021-0685H. This is this year's House Bill 686, which came out of Ways and Means with a recommendation of 19-2. I understand last biennium, it also passed out of Ways and Means. However, it got bundled into one of those infamous omnibus bills at the end of the year that did not get past the governor's red pen because of everything in the bills. This is a bill, this replicates word for word the historic racing bill that Ways and Means has been working on for, I think, about 6 years together. I have urging from Ways and Means to include into the budget. It gives us an additional, oh yay, Representative Taberge is alive and here. We do have a meeting at 1 o'clock. We had a meeting at 10 o'clock. We were worried like crazy about you. We thought your shot had done you in.
we're not that lucky.
Okay, we're not that lucky. We're so glad to see you.
Oh, did I miss something?
No, come down and sit. We're going to take one more vote.
Well, I mean, you voted on preventing.
And 1 o'clock, we need help at 1 o'clock too. So I'll tell you about it. Come sit down. All right, so
Okay. All right.
this puts word for word that bill that's come out of Ways and Means. We get $24 million of revenue. That revenue, unfortunately does not greatly benefit us. It benefits the education fund because it goes into lottery, but that's okay. Anything we do to help education, we've heard some of the pleas from some of the other people. I think we are in favor of that. We had a bill on that that got retained, so we know we need to somehow benefit. So I've been asked to put this in, and I am going to move the adoption of 2021-0685H. Representative Emmerich seconds.
Madam Chair,
Yes,
you happen to hit something that I know a great deal about. And
I'm glad to hear that.
I actually think that you have misstated what happened in the last 2 years. And I know that because I was on the floor with it both times. And the story is that the bills came out of Ways and Means as ought to pass. And eventually there was a floor fight of which I led the opposition to it, and fortunately was successful in both years. So in neither year, is my understanding, did historic racing pass. And so I'm not sure where it might have passed, because I can assure you that in the floor fight, both times I prevailed. So
I am only repeating the information I got from Ways and Means. I don't recall this bill at all. However, we've been asked to put it in by Ways and Means. If they gave me some bum information, I can apologize, Representative Walls, but I did not research it. I used my colleagues' information.
I understand that, but I'm going to severely oppose this. This body, our
Okay.
legislature, does not approve of this, and we have turned it down, not just the last 2 years, but every single year before that. This is totally contrary to what this legislature has done, and it was not a partisan issue. It was a bipartisan, and when I was on the floor, there were Republicans standing next to me opposing this as well. So I think that it's really inappropriate to be putting it in when the legislature bipartisanly has so consistently opposed this. I understand the desire for finding more revenue, but I think this is not an appropriate way to do it. I think that there are huge problems with this. There's huge problems with the companies being brought in to run it. And I think that this is being brought in now without a public hearing. And I think that's a
It
huge.
had a public hearing. It's House Bill 686. It had a public hearing in Ways and Means
Well,
this
I'd
year.
like to hear that, but I'm also telling you that the body itself has opposed what the committee has done every single time without exception, or we would have historic racing, and we don't. And I think that it's a huge problem to be bringing this in and burying it here in HB2. Let's just let it go through or be debated as a bill and not try and circumvent the regular bill process on such an important change to our laws.
Thank you for your comments. I was asked by the speaker and Republican leadership to bring this forward. It has passed out of Ways and Means with a 19-2 recommendation. It has had a public hearing. I
But it has
appreciate your comments. This is where we are. The amendment has been moved and seconded. If you're in favor of Amendment 2021-06H5H, when your name is called, please say yes. If you're opposed, please say no. Yes.
Yes.
Yes. Representative Leishman. Yes. Representative Patch.
Yes,
Representative Walls.
No.
Okay, the motion passes 6-1. We are going to reconvene in Reps Hall at 1 o'clock. Thank you for your work this morning. I'll see you tomorrow morning.
Oh, this?
I-
It looks good, yeah.